Yeah, yeah.
Don't go by that.
Sorry.
Rise.
In the matter of Statutory and its commissioners for Majesty's Revenue and Customs.
My lady,
Good
I
morning.
said I'd come back.
I'm so sorry. As with yesterday, because it's a long morning, we'll have a 10-minute break after about 2 hours at a point that's convenient.
Thank you very much, my lady. So as we'd indicated yesterday, we went away and had took some time to consider with our clients the position on priority, and HMRC now no longer seems to maintain the argument that the transfer of assets provisions have priority over ITPA. And for the reasons I would like to continue to develop this morning, we maintain that TOAA has a role to play as a fallback charge. But for the therefore there is a prospect of a double charge if both provisions apply. We will never seek to double charge. Quite how we address the double charge requires the input of quite a lot of stakeholders. So if I might have the if I might crave your indulgence and ask to come back to you on exactly how we propose to deal with it in the course of submissions tomorrow, we would be most grateful for that.
I mean, speaking for myself, thank you very much for that clarification, which I regard as personally is very welcome. And the question of double taxation, I know you're saying it's proceeding further consideration, but there is still possibly a problem in the sense that whatever policy the revenue adopt in order to avoid a double charge, there is still in law what very much looks like two overlapping charges of roughly the same amount arising out of the same transaction. And if that is truly a consequence of this legislation, one leads one to wonder whether it's being correctly applied in the first place to contracts of employment. I mean, we have bracket, which is actually a first instance decision, and I know it's not challenged in this court, and I'm not suggesting for a moment we should widen the scope of this hearing to do that, but that is perhaps another matter that is instructing you might care to reflect upon.
I'm grateful for that indication, my lord. And as I said, precisely how it is we're going to address the issue of the double charge is including whether there is muscular construction that's possible, or
Yes.
is something that we will come back to.
And also bearing in mind the principle of Majesty, that one should not be untaxed by concession,
Absolutely.
however well-meaning the concession is.
Absolutely. It's as I said, there are many options being considered.
Indeed. Well, thank you, thank you.
So where I got to yesterday was to take you to a first instance decision of the FTT judge, Judge Richards, in the case of Allway, to show you that where the correct test is considered by the court, the type of questions that are asked are materially different to the somewhat cursory approach that was taken by the FTT in this case. And there are two further. I know they are just first instance cases, but that is where the findings of fact are found, and that is where the comparison I seek to make between what was done in this case and what not done in this case and what should have been done, but has been done in other cases, is made clear. I'll take you very briefly to those. They are quite recent cases. The first is strategic branding, and that's in the bundle of authorities, main bundle of authorities at tab 51. This case concerned a company whose business was business consultancy, advising clients on maximising brand value, and it entered into a remuneration trust designed by Baxendale Walker Limited, LLP, forgive me, or its affiliates, and it created a remuneration trust in order to provide incentives to persons among whom were its director. And the facts, my lady, are set out at paragraph 12, my lord, set out at paragraph 12, 13 to 14, just to cast your eyes over those. And then
What is a remuneration trust? Is that something similar to an EBT, or?
I gather that was the idea. That's why I thought it was relevant to bring it to your attention. The types of trusts and contributions and loans are described at paragraphs 35 through to 38. The RT itself is described at paragraphs 15 through to 20. The remuneration trust itself.
And it's again loans.
Yes, it's in loans.
Yeah.
And you'll see paragraphs 44 through to 49 that there were corporation tax inquiries as well as discovery assessments. And then if I could take you to the issues, paragraph 55, that's bundle page 1590, paragraph 55.
So they had a profit and loss account.
Yeah. And one of the issues, issue one, was whether contributions to the RT are deductible in calculating strategic branding's taxable profits. There are three sub-issues. UK GAAP is A, whether contributions, including any fees, in connection with were wholly and exclusively for the purpose of strategic branding's trade, is 55(1)B. And then 1290, we're not concerned with 1290 in this case at all.
And no doubt the revenue raised that as an issue in the case.
I would say so, yes. That's my lady. And then if one comes to the evidence that was considered, which is why I've really brought you to this case, might I ask you to turn to paragraph 66? And if I could invite you to read from 66 through to 70. inquiry that was involved here.
And this was a case where the individual had control over what was paid in.
Yes, ma'am. You will see that there was an argument about certain documents being sham. We aren't obviously relying on any of that aspect here. We're not arguing that anything here was a sham. And then, if I might, take you to findings of fact. So, for instance, 83 to 85 and 88 all deal with the issue of, was this a massive market tax avoidance scheme involving preordained steps. We then go to the issue, which is the wholly exclusive.
And there was a finding that there was.
Yes,
yeah.
there was a finding that there was. And then the issue about wholly exclusively is to be found in paragraphs 152 to 153, which is 1614, the bundle. So you've got the party submissions there at 152 and 153. And then you've got forgive me, my lady, my thoughts. May I take you then to...
Where do we find the conclusion on all this?
Yes, so there's the part of the exercise is to show the care with which this decision is taken, not least in discussing all the case law. And yesterday, my Lord, Lord Justice Phillips asked if it's taxable, and I made the point that there isn't a necessary correlation between it being taxable in the employee's hands and being deductible in the payer's hands. That was a case of Marlborough that said that there needed to be, and this case, the argument was that there didn't need to be. Marlborough is discussed at 161.
I mean, usually in this kind of area, discussing the facts of other cases isn't going to help one very much. One needs to understand the legal principles, and then it's a question for the assessment of the fact-finding tribunal.
Well, absolutely, and what we're saying is that where the correct principles have been taken into account, the conclusions of fact, and the factual inquiry and the detail with which the conclusions of fact are set out are seen in these cases as opposed to in our case. So
That will depend to some extent on what evidence is available. In a case where there's no profit and loss computation that reflects some sort of decision on the part of the revenue, if the computation is produced, say, by the revenue as an example of what might be the computation, or if it's produced by the by the company, showing what was deducted, what they regarded as deductible, so that there could be a proper focus on the issue. And was there a proper focus on the issue in this
We
case?
would say there certainly was a proper focus on the issue in that the questions that were put to the witnesses, Mr. Hall, Mr. Parr, and the appellant himself, were clearly focused on trying to understand the arrangements, trying to understand how the fee structure worked, trying to understand how the fee receipts were then paid over, understanding what deductions were available, whether or not permissible, and made by the employer. This was all we sought to establish through the examination, because there were no other documents available than that was before the tribunal, and that certainly didn't include profit and loss accounts. So the focus was definitely there in this case, and it included matters such as the fact that Mr. Hoey himself gave evidence that he didn't have very much to do with Penfolds. I mean, they were his employer, but he found his work, he secured his work pretty much through his own efforts with the agencies through whom he then got, say, Aviva. And he stayed with Aviva despite that change between Hamilton Trust and Grange, where there was that, if you remember, there was a resignation letter, and Mr. Hoey didn't remember anything about the resignation. Was surprised.
Sorry, standing back from the detail, it remains the case, doesn't it, that until you put in your speaking note on transfer of assets abroad, after the evidence had been given them as part of your replies, as part of your final submissions, there hadn't been any focus pleading on the issue of wholly and exclusively, other than just the general putting to proof to be found in your statement of case. And if you look at your cross-examination, I mean, again, it was only when the tribunal intervened to ask that it became clear that you were actually focusing on the issue of wholly and exclusively in the questions you were asking.
My lord, that isn't quite accurate.
Well, that may not be quite, but I mean, in broad terms, is that not an unfair summary?
Is that not an unfair summary?
Well, sorry, I'm big about it. Is that an unfair summary is really what
I would never accuse you, my lord, of being unfair.
I've got my negatives in the twist, I apologise.
But what I would say is that our skeleton argument did put them on notice that wholly exclusively would be tested, and it was tested in cross-examination. It is for the taxpayers, ultimately, and perhaps it's worth my while saying it here. It is for the taxpayers to discharge the burden of showing that their assessments are wrong. Now,
but
in
there can be
towards drinks, for instance.
But evidential burdens can shift, can't they? I mean, it seems to me on this kind of an issue, one is entitled to take as one starting point the proposition that remuneration paid to an employee is prima facie deductible, unless somebody can explain why it shouldn't be. And that will put an evidential burden on the revenue to come up with to run the wholly and exclusively point as a positive part of their case.
I mean, if that weren't the case, sorry to interrupt, and to move on from my lord's question to you, if it weren't the case, every company that made a deduction in accordance with GAAP for salary payments, remuneration payments, would have to prove it every time.
My lady, there is a world of difference between those sorts of scenarios and this sort of scenario. We are here looking at a tax avoidance scheme. We're not looking at a straightforward employer-employee relationship where the test is the same, but it's easy to prove the test because all you need to do is to show that these are ordinary everyday arrangements. This is my employee. I'm paying market rates for him. He's doing the work that I expect him to do, he or she. And in that case, the wholly and exclusively test is easily met. It is, as it were, one of those that is easy.
But excuse me, all those conditions are clearly met in relation to Mr. Hoey. He was employed by the offshore employer. He was paid a market wage. There was no artificial inflation of the market wage, and it was in return for the work that he supplied.
But my lord, that misses the construct within which this was happening.
That's just the motive.
But, well, for the transfer of assets provisions, we know from the upper tribunal in Scots Atlantic that one is supposed to, even when looking at the purpose of the payments between the employer and the EBT, to look at the fact that it takes part as part of a context.
Well, firstly, that decision is not binding upon us. It's not a tribunal decision. And secondly, I mean, that was a case where the findings of fact made by the fact-finding tribunal were adverse. in the sense that it was decided that the test was not satisfied. And the only question was whether there was an error of law. I got that the right way around. Sorry, it was but anyway, it was yes, but here it boots on the other foot. We have a finding of fact by the FTT, effectively, that it was deductible.
But, my lord, we are challenging that finding of fact on the
You've
basis
got to
that
show
the
there's
error
an
of
error
law.
of law.
But what we're trying to say is that although having heard all the submissions from us on the relevant principles to apply, having heard all the evidence itself shows that he didn't take into account that there might be a purpose beyond the remuneration being paid, i.e. to assist with the tax saving on the part of the employee. It doesn't register the importance of the fact that profits were being earned elsewhere in the structure, wherever, by unconnected persons, which we say is entirely relevant, entirely relevant to understanding and discerning the purpose for which the contributions were made. And it is, I recognise that Scots Atlantic in the Upper Tribunal is certainly not binding on this court, but we do say that, for instance, if I could take you to it, paragraphs 53 and 54 do assist in 53, 54, and then later do assist with that, with the how to approach a contribution made within the context of a scheme.
Which tab is it again?
I'm just about to tell you that, my lady.
29.
Thank you.
39.
29.
29.
29 it is, yes, exactly. Thank you so much. Tab 29. So if I could take you to I could take you to the facts I think you're familiar with, but there for your note there are paragraphs 3, 4, 9, 10 and 11. So appellants took part in arrangements which was hoped would circumvent the provisions of Schedule 24, enable them to claim deductions related to the cost of rewarding their directors and certain employees without those directors and employees becoming liable to income tax and national insurance contributions on the benefits in the relevant period or within 9 months thereafter. So again, there was a corporation tax deduction sought as well as the saving of NICs and PAYE in the hands of the employees and the directors. And then if I could take you to paragraphs 47 to 53, which we say set out a very clear process of analysis where the correct principles have been taken into account. So our conclusion in relation to that is it makes it unnecessary to determine this. However, in case this should go further, because technically the denial of 74 precludes Schedule 24, we propose to say something about this topic. And then the issue addressed between the parties, Cornhills, and the effect, and then the word over the page, my lady, my lord, there's a reference to Bentley Stokes. However, determining, I'm at paragraph 49 right now. However, in determining the object of a taxpayer and incurring an expense, the FTT must observe a number of principles, and the failure to do so may render its conclusions erroneous in law. First, the taxpayer's object in making the expenditure has to be found. It inevitably follows that, save in obvious cases which speak for themselves, the FTT needs to look into the taxpayer's mind at the moment when the expenditure is made. And we say, when you've got a tax avoidance arrangement within which a payment is being made, it isn't a straightforward situation that speaks for itself.
Well, why not? If it's just a payment of proper remuneration for work done.
Because the context in which it takes place, my lord,
Right.
we say,
Sorry,
provides an additional purpose. It provides an additional purpose.
All right, that's the submission anyway. Yeah.
Because if a payment were to be made, which was a direct payment from the employer to the employee, there would be PAYE and NICs involved, or certainly the employee would be taxable in respect of the receipt. If the employer happened to be abroad, that he or it wouldn't have to necessarily operate
But all that aspect was sorted out by arrangers.
Yes, so there's a redirection, one might say, in that situation.
So
But
why is that not the
nonetheless,
end of the story?
because ultimately that goes to the taxability in the hands of the employee, whereas what we're looking
That's
at
where it
here,
ought to be. It's the employee who's taxable.
what we're looking at here, my lord, is the amount of the income abroad, which is determined on the wholly exclusively basis, which is then attributed to him. I recognise that
By
this
way of a
is
penal double charge.
Why isn't the passage quoted from Lord Justice Milliton Vodafone at paragraph 51 applicable? The payment was made exclusively for the purposes of the trade. It was to reward and remunerate the contractor. The fact that it also secured a private benefit was merely a consequential and incidental effect.
And what we would say is that if you could look down a little further to 52,
Yeah.
which links the two, some effects are so integral, so much a part of the purpose, that they cannot but be seen to be the purpose. So that is why we say in these arrangements, the saving of income tax in respect to the loans and the saving of NICs was so integral a purpose of these arrangements. That was the 80% that they were promised. That is, we say, a purpose, not merely an effect. It isn't
I thought
incidental.
the subsidiary or secondary purpose was making a profit for other persons.
Whether it's secondary or tertiary, any purpose that is beyond wholly and exclusively for the purpose of the trade is fatal to the deduction.
The trade of that company.
Of that company alone.
So if a PLC engages somebody, no doubt, at a very high salary, and pays their salary and gives them the title of group managing director, and their role is expressly to manage and coordinate the affairs of a group of subsidiaries, thereby ensuring that those subsidiaries make more profit, is his salary not deductible?
Well, his contract in those circumstances would be with the holding company, the parent company.
Yes.
He would be providing his services to the parent company, which would include these other things.
But the
effect-
purpose is to make profits for the subsidiaries.
The purpose is for the holding company to acquire his services, to do what they need to do. His
To make
services are
profits
provided
for
to the holding
no,
company.
the whole purpose of it is to make profits for the subsidiaries, which then will come back to the parent through dividends.
I am tempted to say, my lord, that my learned friend's biblical response might be the one to bring here, because we need to look at exactly what the...
But it isn't,
thought
because
process might be.
although you're addressing this in the context of TOAA, you're saying to us that the wholly exclusive test isn't satisfied if there is any secondary purpose of benefiting a different trade, a different trading body. And it seems to me that as a proposition would have the most extraordinary effects on all sorts of trades which are carried on perfectly properly, because it's going to be very often the case that the purpose for which somebody is employed is not limited to benefiting solely to benefiting the employer. It may be that obviously the reason they're doing it is to benefit, but it may be that it's essential to acquire that benefit, that it also benefits other companies.
My lord, the reason I say make that submission is because of Vodafone Cellular and Shaw, which makes a distinction between providing services to the parent, not providing services to the parent. The parent getting rid of an onerous contract for its own purposes was fine. A parent getting rid of an onerous contract to benefit subsidiaries would not have been fine.
Well,
the court found on a proper analysis of the purpose that actually it was only to benefit the parent company that the onerous contract had been disposed of, had been bought off with the cost, and therefore the fact that there was an effect for these subsidiaries didn't taint what was otherwise a wholly and exclusively purpose.
Well, putting your excuse back to you, let's not worry about things other than employment contracts. What's the position of a company whose employee is going to part of his job is to manage the affairs of other companies?
He's an employee of the company that that employs him, and it's part of his role that he provides to his company.
Yes.
The effect of that may be to assist the other companies to do better, but ultimately that will redound to the benefit in terms of shareholding value of the shares that are held in those companies by the parent company. So one would say that actually that does benefit the parent company and is for the purposes.
But it also benefits the subsidiary.
Well, that's an effect, one would say, in that scenario.
What about paragraph 55? The choice that the taxpayer makes about how to order his affairs.
That's right, and if I may read on, it's exclusively for the benefit of the trade. And what we say here is this is
No, it doesn't mean that if the choice involves a duality of purposes, that doesn't mean necessarily that it's not wholly and exclusively for the purposes of the trade.
And my lady, if I could just read that first sentence. A trader may have a choice of a way in which it achieves an end which is exclusively for the benefit of the trade.
Yes, so we've got the purpose, which is remuneration, which prima facie is wholly and exclusively for the purpose of the trade. It's only because you say there are these other possible purposes that purpose might not be. Yes?
Well, it is a purpose of at least two other candidates. And because there are these two other candidates, which are not for the purposes of its trade, certainly the fact that it retains no profits and doesn't seek to make any profits for itself, but has profits arising elsewhere, is not something that is exclusively for the benefit of its trade. So the choices that this company is, that the enterprise that is making, is not exclusively, but all of those are not for its benefit. And
hold on, you've got a purpose, a remuneration purpose, prima facie, wholly and exclusively for the purpose of the trade. You are entitled as a taxpayer to order your affairs in a way which incurs the least tax liability. And what Vodafone says is that the fact that a choice is influenced or dictated by tax consequences doesn't necessarily mean that becomes a tainted purpose.
And that's the point, my lady. It's not necessarily.
Right.
But it can be. The point is, it needs to be, the choices that are made must, if A choice or B choice would be both exclusively for purposes of the trade of the payer, then you can choose A or B. But if choice A is not exclusively for the trade of the payer, i.e. paying it through the EBT in a way that ensures that profits redound elsewhere, so there are two benefits there. One is that there's a private tax advantage to the individual, which unless there is evidence to show that that is what is necessary in order for it to benefit the trade of the trader, could be a non-trade purpose. Any profits that arise as a result of this employee's work are enjoyed elsewhere as well.
But at the time that the payments were made, the Rangers' decision hadn't occurred, and it was a perfectly lawful means of making payments, wasn't it? The object of the employer was to remunerate, and this was regarded as an entirely acceptable means of remunerating. So I'm just struggling to understand what this other ulterior purpose is. In that world, yes. I can see that Rangers has changed the landscape, but in that world, why wasn't that a perfectly proper ordering of the employer's affairs?
My lady, what we would say is that the concept of remuneration here, quite apart from Rangers, needs to look at the fact that the loans were not expected to be repaid and for the most part have not been repaid, and certainly Mr. Hoey's not been repaid. So the loan element of it, as it were, is not, I know we're not claiming sham, but it's
well,
so
that's important. You're not claiming sham.
We are not claiming sham.
Therefore they were loans.
The difficulty with, we would say though that with Ramsey, you take a realistic view of the facts. One of the arguments there was a whole panoply of arguments dealing with the way that the loans were going to be treated. The concession that Rangers applied doesn't mean that the other ways of analysing it are not equally available. So even if one forgets the redirection argument, if a realistic view of the facts is, as the evidence showed, that the loans were never expected to be repaid, then you treat them as really being payments over. And that's how we would have been arguing Ramsey in the fullest sense, even had the redirection argument not been conceded. So the fact that it is set out as a loan but is never expected to be repaid begs the question as to its proper analysis for tax purposes. And we would say in that context, even regardless of ranges, it is earnings.
If it's not sham, then it must be a true loan, in which case there's no change to the balance sheet position of the person who makes the loan. He just swaps money for a debt in the other direction. And that debt remained outstanding unless and until it was relieved or called in. And part of the original tax planning was it should not be called in, or at least absent special circumstances, and it would therefore help to reduce the taxpayer's estate at the date of his death. I mean, that was part of the perfectly legitimate tax planning.
So the analysis would go something like this, my lord. The payment to the EBT is not deductible because the aim is to provide earnings to the employee, which are his own earnings. The payment to the employee in this way saves him tax. It saves him tax, and therefore, unless there can be a squaring of that circle in the way that paragraph 127 of Allway suggests, that it has to be shown that that would have benefited the trade of the employer. We say that that payment is an extraneous purpose. It is not a trade purpose. Quite apart from that, the fact that the money was set out as payments to the EBT and then an onward loan which was never expected to be repaid to by Mr. Hoey, we would say constituted earnings in his hands, which, because it was tainted, it would be taxable in his hand as earnings, but because it was tainted by this purpose of saving him tax, which doesn't seem to benefit the trade, because the trade doesn't profit from it, means that it was not a deductible expense. I recognise that wholly and exclusively applies in all contexts, and we are saying that it needs to be context specific. So when the comparisons are given between avoidance schemes in which payments are made and ordinary everyday transactions which have remuneration at a market rate in ordinary business commercial situations, we say that that is not an apposite comparison, because it is fact specific, it is context specific, and it depends very much on the purpose of the payer at the time the payments are made.
But wouldn't this payment have had to be made anyway? We've got a payment of remuneration that would have had to be made, because otherwise Mr. Hoey wouldn't have provided his services.
Well, that's the point. That's why I've laid the point that Mr. Hoey actually found his clients himself.
Well,
so
you're not arguing sham. This was an employer providing, trading, so as to provide contractor services to an end user. How it did it doesn't matter, because you weren't arguing sham. So we've got a perfectly legitimate trading situation on your case.
My lady, nobody's denying that there was a trade here.
So they would have had to pay Mr. Hoey. His rate was 550 plus VAT a day, and that's what they paid. How they structured that payment doesn't alter the fact that that was the purpose. So in that situation, why does it matter whether there was some sort of other motive or another effect? Isn't this a situation where the purpose is the purpose, however you structure it?
My lady, the having to pay him, we say, arises from the broader arrangements, because he became an employee knowing that this is what would happen with the clients that he was sourcing.
That doesn't matter.
Well, we say that it can't be irrelevant, my lady, because it is so much a part of why Penfolds was there as an employer within the structure and providing his services through the series of contracts. We say that the two can't be dissected, and it would be an unrealistic view of the facts to say that there is an obligation that is freestanding as between these two. That obligation exists as a result
But presumably there's an employment contract. That's why we're in this legislation.
Yes, of course.
Once you've got, and presumably you rely on that employment contract
Absolutely.
as a genuine contract.
Absolutely.
Well, in which case, he provides his services. There is a genuine obligation on the employer to pay for those services. And if the rate is 550 and that's what they pay, isn't that the end of the story?
What?
I just don't understand. Sorry.
As my learned friend reminds me, the end user is certainly being charged $5.50 a day. It's it's not clear that Mr. Hoey receives by 50 a day. He certainly receives something by which
He won't receive more, will he?
he probably will. He
No.
shouldn't
No.
receive more.
It's
100%.
highly unlikely.
One way or another,
He's going
fees
to.
are going to be creamed off as it goes
Yes.
round the circle.
Yes.
I mean, it doesn't matter how. One way or another, all the expensive people who dreamt up this scheme are going to take their cut. I mean, that's just blindingly obvious.
Yes, absolutely. What I was going to say, my lady, though, is that the way that the question was put suggests that there is a binary distinction between sham and having to give total tax effect to all the transactions that took place. And we know that that isn't the analysis that applies. We know that even though something isn't a sham, you still look to take a realistic view of the facts in the light of the legislation purposely construed. That's the whole Ramsey world,
Yeah.
of which redirection forms a part,
Yeah.
but just a part.
Yeah.
So the fact that it's not a sham, the fact that there is a real company with real employees and a real contract of employment and real money going through does not necessarily mean that the tax outcomes follow in the ordinary way. It depends very much on the circumstances surrounding those transactions, which is why I say it is entirely relevant, even in the wholly and exclusively context, to take account of the wider transactions. Those are our submissions on that point. So those are where I had got to in relation to Brander. Bly is another one of those cases. I would suggest strongly that one also looks at Bly, but because of the analysis again it's FTT, but with the right test in mind, the quality of the analysis is just a world apart from what we see in our case. Now, you will say to me, but just because it's very circumspectly written in this decision doesn't mean that he didn't have the right principles in mind. And that is what the upper tribunal also said.
Yeah.
But they both, we say, fail to recognise that just because something is remuneration is not necessarily the end of the question. You need to see if there is any other purpose. And the decision at paragraphs 16, I can take us to the core bundle, at paragraph 16,
Which is it, the FTT or the UT?
it would be the FTT decision first.
Yep.
So if I would take you to the FTT decision, it's core bundle, tab 17.
Yeah. (322) to 323.
Yeah.
Which page is that?
322, I think.
Yes. we talked through this.
So the decision in the FTT I took you to last evening, paragraph 166, in arriving at the profits, I think it is not in dispute the amounts paid by their salary, so the contractors are valid deductions. That's because no one was disputing, we haven't put that in dispute. The payments into the trust are however potentially more controversial. I therefore look to the judgment of Lord Hodge in RFC, i.e. suggesting that that is the complete answer, which might indicate their true nature.
Well, on the other hand, the judges expressly recognise that the question is potentially more controversial, no doubt in the light of all the submissions he has received from you and the opponent.
And
So
he's
he would-
recorded at 164 that you were arguing duality of purpose.
Yeah.
Absolutely, but when it comes to looking for the answer, he stops only at remuneration, because that's what he does at 167.
But that's, well, all right, we've been over this ground
Yes.
before, but remuneration is prima facie deductible, and there's a cases put to lead to an opposite conclusion. And that surely is what he was considering.
And the evidence before him included that profits were being earned elsewhere. This was part of wider arrangements, and that the aim was to achieve a tax saving for Mr. Hoey, which didn't actually advantage the company at all, i.e. the payer company at all. In those circumstances, some cognizance of that, what ought to have been made, at least expressly, so that we knew that that was at least part of his consideration, whereas we would say it clearly wasn't. Not that he didn't mention it.
Your
It
quibble
clearly
is
wasn't.
with his "they therefore properly fall" words.
Yes.
Yeah.
Yeah. If he'd said, in light of all the evidence, my conclusion is that no other purpose has been, or that it's just salary, that would have been unchallengeable.
It would have been much more difficult to challenge. But it's not just that he excluded those words. We say that this is a very long and detailed judgment. But if you look at the analysis and the discovery assessments, for instance, it's this is a judge who's taken some care over things. But when it comes to this, he's just skipped from one into another, which suggests that that was the only part of his thought.
Well, I think it may be quite fair when you conceded that the amounts paid by way of salary were validly deducted.
We didn't. Well, it wasn't in dispute before the tribunal. It's not the
So
same.
you conceded it.
And that's the job of tribunals, is to decide points in dispute, not to embark on.
But as you said to me before, I think it would follow from your argument that the amount of salary described as salary would also not be deductible. And so once you weren't arguing that, and then the judge decides that this is also salary, it follows, and you weren't disputing it.
My lord, there are reasons one doesn't necessarily run every point. There are reasons why one doesn't necessarily dispute every deduction.
Of course.
And it doesn't mean that it's because each of the other things that are similar should follow the same rationale. And that is, we would say, a misconception both on the part of the FTT as well as the UT, because they also relied on that.
So is there an error in the first sentence of 166 where the judge says it's not in dispute that the amounts paid by way of salary are valid deductions?
We would say that is an error, because it wasn't disputed as opposed to it being accepted that they were valid deductions.
Sorry, it's not in dispute that they are valid deductions.
Yes, we didn't take the point. It's not the same thing.
Well,
as
did you
saying
make
that
that clear?
Yes, of course we made that clear.
That you were saying they were not valid
No,
deductions,
didn't
but you
express
weren't
it.
challenging
I
it
don't
in the
remember
proceedings.
verbatim, sorry for overspeaking.
No.
I don't remember recall of this remove expressly stating that they weren't valid deductions. What we said is we are not taking a point in relation to that. However, we are with this, and there was a distinction made. We say that those are the errors that the FTT made, and we say we have set out in quite some detail in our skeleton argument why we say the UT didn't spot the errors of principle, i.e. that the wrong testament applied, didn't see the errors in the way in which the FTT should have evaluated the evidence it didn't. I don't wish to labour the point. You have our submissions on that point.
We do.
And I think maybe it's a better use of time to move on to the EU. Submissions. So the position we have here, happily, is that we agree with the tribunal in its in its view that
In its wisdom, it got this bit right.
yes, we're very happy about that. Which is that we say correct in finding that FMOC was not something that needed to be independently considered because
Free movement.
forgive me.
Sorry.
Free
getting
movement of
Free-
capital.
Free movement of capital. So here we are concerned with an employment contract which engages the transfer of asset provisions.
Yeah.
We have the payments to the EBT and the payments of the loans from the EBT. We say the payments of the loan, the payments to the EBT and the payments from the loan of the EBT, both are necessarily subsidiary to the employment contract, because that is the thing that gives rise to the income that is then paid across to these two into this particular EBT and then out of the EBT. So we say that the part of these arrangements that engages EU law, engages the transfer of assets provisions is the entry into the employment contract.
Yep.
And we say that that naturally falls within free movement of workers. And that this is, and that given that the enterprises with whom the employment contract was entered into are cited in a third country, free movement of workers doesn't extend to third countries. Mr. Hoey can't rely on it. We say that to the extent that there are these other movements of capital, they are entirely subsidiary. They are inevitable consequences of the payment of his remuneration, it being accepted that these are remuneration, both by Mr. Hoey and by the revenue. And that in that scenario, and I'll take you to Fidium Finance to show you, in that scenario, FMOC it is not something that needs to be independently considered. The fact that it is the only thing that might be available to a person relying on a third country, or an enterprise based in a third country, is neither here nor there because of FRI 100. The territorial limits must be maintained. So just to break down those submissions into that was just an outline, obviously. My learned friend says, in the first instance, how do you know which treaty freedom to identify? And he says you must start by looking only at the legislation in order to work out which freedom is identified. And we say, well, that's certainly a starting point, but where the legislation itself doesn't make clear which freedom it engages predominantly, then you have recourse to the facts.
If transfer had been defined so as to be limited to capital, rather than...
Well, yes, my lady, if transfer had been defined in a very limited way, yes. So so many things are capable of being capital, movements of capital, and I'll take you to the annex in a moment. And given the breadth of the transfer of assets provisions, so many things are capable of engaging the transfer of assets provisions. You can have a transfer of assets engaged if you enter into a consultancy contract. You can have it if you set up a trust and transfer assets into it. If you establish an offshore company and you transfer funds into it. All of these are direct investments. All of these would engage the transfer of assets provisions because they are a transfer of assets by virtue of which the income arises to a person abroad, i.e. the entity, enterprise, whatever, that you set up offshore. So the transfer of assets provisions is capable of applying in a variety of situations, not exclusively ones that are limited to movements of capital. And this is this, we say, in Mr. Hoey's case, is an archetypal example of a transfer of assets that falls within not a movement of capital, because an employment contract isn't a movement of capital.
But what you're saying, if the legislation had been more specific, Mr. Mullen might be right. But you're saying, given its wide potential application,
you don't just
many freedoms might be engaged,
exactly.
And therefore you have to look at the facts.
That's exactly right, my lady. And if I could take you, say, for example, to FII number 3, which is...
Which court are we in? This is the ECJ. I mean, the CJEU, what you're taking this case. There's so many FII cases.
Yes, my lord. It is, I think, the CJEU, and it's in... well, I've got in bundle 3 of my authorities, but...
Which tab?
I'm just about to give that to
Thank
you.
you.
FII number 3 is at 67. 67 of your authorities bundle.
Yeah, this is the 2012 reference.
Yes, my lord. And what we have is, if I could take you to paragraphs 90 to 94.
You've got a page reference.
Yes, my lord. It is page 2101 of the bundle. Internal page, report page 449. Now, what 90 to 94 make clear is that where the national legislation, it is clear, which freedom is engaged, you need to look at the national legislation. That's the starting point. And then 91, the national legislation intended to apply only to those shareholdings which enable the holder to exert a definite influence on a company's decisions and to exercise its activities, all within the scope of Article 49 on freedom of establishment. So when you've got definite influence, that's
subsidiaries for short.
Yes.
As opposed to portfolio holdings.
Absolutely. And then on the other hand, national provisions which apply to shareholdings acquired solely with the intention of making a financial investment without any intention to influence the management and control of the undertaking must be examined exclusively in the light of the free movement of capital. The national rules at issue in the main proceedings apply not only to dividends received by resident companies on the basis of a shareholding that confers definite influence over the decisions of the company paying dividends and enables its activities to be determined, but also to dividends received on the basis of a shareholding not conferring such influence. Insofar as the national legislation relates to dividends which originate in a member state, it cannot therefore be determined from its purpose whether it falls predominantly within the scope of Article 49 or Article 63, 49 being establishment, 63 then being free capital. In such circumstances, the court takes account of the facts of the case in order to determine whether the situation to which the dispute in the main proceeding relates falls within the scope of one or other of those provisions. And we say that that's true even at this is a dividend case.
Yeah. Yep.
And the point with dividend cases, we would say, is that the dividends clearly do involve movements of capital. You've got the dividend itself. You've also got the direct investment in the enterprise that gives rise to the dividend. So you've always got FMOC. The question is there another is there primarily engaged another freedom? And that is what the court is looking at here. And if you can't determine from the legislation, say it doesn't require a 30% shareholding, so it can apply even if you've got a 1% shareholding, you're not in the definite influence world, therefore you're not within establishment. And FMOC may be the right freedom. But what we say is, if I could just also take you to Haribo, which is at 65, tab 65.
Sorry, before we leave that, I see there's a sideline passage at 100 and 104. Is that something worth looking at now, or is that not relevant? Or does it really just repeat what you've been telling us?
I may as well take you to 100 because I was going to cite it anyway. Since the treaty does not extend the freedom of establishment to third countries, it is important to ensure that the interpretation of 63(1), that's the free movement of capital, as regards relations with third countries, does not enable economic operators who do not fall within the limits of the territorial scope of freedom of establishment to profit from that freedom, such as that risk does not exist, etc. But what I would say, my lady and my lords, is that what this is trying to say is that when you have undertaken the exercise of working out which freedom predominates, you don't then, and if it doesn't apply because there are territorial limitations, you don't then look to the next freedom that may apply to a person from a third country and say that freedom must apply, because that is exceeding the territorial limitations of that that are intended to apply. So you don't come in by the back door just because you're a third country and you happen to have a movement of capital. If in fact, on the legislation and the facts, you clearly there is another freedom that does predominate. Yes, and what I was going to do is to take you to Fidium next to show you that. But
I thought you said you were going to go to Haribo.
Yes, I will take you to Fidium once I have taken you to Haribo. Haribo itself, rather fun name, but we have taken to
Don't
paragraph.
distract us. Time for a break.
Paragraph 34 of Haribo.
Sorry, which tab are we at?
We are at tab 65,
Oh.
and it's paragraphs 34 to 36 of the judgment.
And a page reference.
So it's at page 2023 onwards. So 2023 is where the section starts at section paragraph 31, and then all the sideline parts rather beautifully are over the page. Might I just invite you to read paragraphs 34 through to 36? And we say that this and so, having analysed the legislation, they go on to hold Article 38 that FMOC is solely engaged. And what we would say is that we would say that these are dividend cases, and as I said, in dividend cases you always have free movement of capital, which is an important feature of the arrangements. Whereas what we are looking at in our case is the movement of capital is in and of itself a consequence of the primary activity, which is the employment, and it is the means by which the employment is remunerated. So we say that when you look at the legislation to start with, the transfer of assets provisions are engaged with the employment contract. The income arises as a result of that, computed as profits, obviously, in this circumstance. And then the transfer by the employer into the EBT and the transfer by the EBT by way of loan to Mr. Hoey are means of providing that remuneration. On those facts, we say, given that the TOAA itself doesn't clearly identify which freedom is engaged, the facts indicate, we say, that the worker freedom is engaged. It's a separate question whether or not there is, in fact, an infringement of the worker freedom, because it's not, he provides the services in the UK to a UK entity. Query whether or not there is any discrimination based on nationality in any event. But the freedom that is relevantly engaged, we say, is worker freedom. Everything else is subsidiary to that. But the worker freedom is not available to be relied upon in this case because the employer is based in a third country.
And the same would be true if it was freedom of establishment.
Yes, freedom of establishment as well, and services. Because those three are limited to members of EU member states only. And to make good this analysis, I was proposing to take you to Fidium Finance. which is to be found at tab 64. The facts briefly put, well, in fact, the holding does it at age 3, but if I might just invite you to read that, that might be quicker.
Forgive me, I missed the reference.
Forgive me, it's tab 64.
Yes, no, which page?
We're actually on the first page of that. It's the holding at the moment.
Oh, you want the holding first?
Head note and holding. And then I'll take you to the relevant paragraphs. The point that the question that was really being asked is which of the two freedoms could be relied on, and if and whether one was subsidiary to the other, and if the territorial limitation meant that FMOC couldn't be relied on because it was a subsidiary freedom engaged. And if I could invite you to go to page 1975 of the bundle. Paragraph 23, at the outset, it needs to be made clear that the rules of dispute apply to companies established outside the EEA, credit institutions established in the member states of the European Economic Area subject, pursuant to Article 50B of the national rules, special rules, which are not at issue in the questions preferred. And then Fidium Finance is established, paragraph 24, Fidium Finance is established in Switzerland, grants credit on commercial basis to persons resident in Germany. 25. Contrary to the chapter of the treaty concerning the free movement of capital, the chapter regulating the freedom to provide services does not contain any provision which enables service providers in non-member countries and established outside the European Union to rely on those provisions. As the court found in its opinion at 81, the objective of the latter chapter is to secure the right to provide services for nationals of member states. Therefore, Article 49 cannot be relied on by a company established in a non-member country. And then if I could ask you to move forward to paragraphs 32 through to 34. Actually, perhaps after 31 sets out the argument. It has been argued that before the court that in such circumstances, and in the light of the wording of the first paragraph of Article 50, the provisions concerning the freedom to provide services apply as an alternative to those which govern the free movement of capital. The argument cannot be accepted. Although in the definition of the notion of services laid down in the first paragraph of Article 50, it is specified that the services are not governed by provisions relating to freedom of movement for goods, capital, and persons, that relates to the definition of that notion and does not establish any order of priority between the freedom to provide services and other fundamental freedoms. The notion of services covers services which are not governed by other freedoms in order to ensure that all economic activity falls within the scope of the fundamental freedoms. The existence of such an order of priority cannot be inferred, they then say. 34. Where a national measure relates to the freedom to provide services and the free movement of capital at time, it is necessary to consider to what extent the exercise of those fundamental freedoms is affected, and whether, in the circumstances of the main proceedings, so again, go to the facts if you can't work it out from the legislation, one of those prevails over the other. And then they cite several authorities. The court will, in principle, examine the measure in dispute in relation to not only one of those only one of those two freedoms, if it appears in the circumstances of the case that one of them is entirely secondary in relation to the other and may be considered together with it. And that's the thought process that they then apply in the later provisions, in the later paragraphs. So at paragraph 40, they state, although Fidium Finance is not a credit institution within the meaning of community law, insofar as its activity does not entail the receiving of deposits or other repayable funds from the public, the activity of granting credit on a commercial basis constitutes a provision of services. And then they explain at 41 about capital movements, and then talk about loans and credits granted by non-residents to residents featured under heading 8 of the annex. I'll take you to the annex in a moment. It follows that the activity of granting credit on a commercial basis concerns in principle both the freedom to provide services within the meaning of Articles 49 and the free movement of capital within the meaning of Article 56. It is therefore necessary to consider whether, and if necessary to what extent, the rules in dispute affect the exercise of those two freedoms in the circumstances of the main case, and whether they are capable of hindering them. And then it sets out the dispute. And then if I could ask you to go to paragraph 47. In the light of the considerations set out at paragraph 25, to which I have taken you, Article 49 cannot be relied on by a company such as Fidium Finance, which is established in a non-member country. As regards the free movement of capital within the meaning of 56, it is possible that by making financial services offered by companies which are established outside the EEA less accessible to clients established in Germany, the rules effectively make those clients less inclined to have recourse to those services, and therefore reduce cross-border financial traffic relating to those services. However, that is merely an unavoidable consequence of the restriction on the freedom to provide services. So that's when they say that the capital action, as it were, is subsidiary. It's an unavoidable consequence of the restriction on the freedom to provide services. It is apparent, at paragraph 49, it is apparent in the circumstances of the main case that predominant consideration is freedom to provide services rather than the free movement of capital. Since the rules in dispute impede access to German financial market for companies established in non-member countries, they affect primarily the freedom to provide services. Given that the restrictive effects of those rules on the free movement of capital are merely an inevitable consequence of the restriction imposed on the provision of services, it is not necessary to consider whether the rules are compatible with Articles 56. So what we say is that based on Fidium Finance, it is appropriate to look at the transfer of assets provisions to see whether they are only engaging one set of one freedom or many. We say they engage in several. One then looks to see which is on the facts, the freedom that is predominant, which is the one that is primarily engaged. And because the transfer of assets in our case is engaged on the facts by the employment contract, we say that it's the free movement of workers.
Forgive me, that's not quite. You just sort of slipped into saying, well, it's an employment contract, but the whole issue here is that it's not just an employment contract, but it is an asset, which is the right to provide employment services. And that asset has been transferred or created. In other words, the right to provide Mr. Hoey's services is no longer situated in this jurisdiction, but has been moved to the Isle of Man or to Guernsey. And it's that asset which we're looking at here. The provision of services hasn't moved at all. Mr. Hoey is still providing his services in the United Kingdom. What this is all about, and why you're able to attack it, is because the asset has been moved, and the asset is the capital. This is all about the movement of the capital.
What is the capital, my lord, in that analysis?
The capital is the asset.
So perhaps if I could take you to the annex to show the types of things that are included in movements of capital. So that is within the additional, no, forgive me, at the end of the third bundle of authorities.
Yeah. The main bundle.
In the main bundle.
I'm sorry, I missed that reference. Where are we?
In the main bundle of authorities, it is at sorry, forgive me, it's my mistake. It's, I think, in the legislation bundle.
That would make more sense, I
Yes, it does, indeed. Forgive me. My learned junior reminds me that it is referred to as the nomenclature. And that is set out at tab 12 of the legislation. So I'm just taking you through the annex, and you will see, as the upper tribunal noted, that this is quite a comprehensive list. And what it doesn't include is contracts for services, such contracts of employment. It has direct investments in real estate, operations normally dealt in the capital market, collective investment undertakings, operations of securities instruments normally dealt in on the money market, operations in current deposit accounts, etc. None of these, we say, so when one looks at personal capital movements, you've got loans, gifts, endowments, etc. Transfers of assets constituted by residents in the event of emigration at the time of their installation or during the period of staying abroad, transfers during their stay, etc. So these are quite broad. These are non-exhaustive. It is accepted that this is a non-exhaustive list, but it is clear from what they are doing is that they are looking at it sounds like stating the obvious, movements of capital, as opposed to something that is deemed to be an asset by the national legislation, such
But
as
the starting point, though, is that you are saying that there is here a movement of capital, aren't you?
No, transfer of assets.
We say there's a transfer of assets.
But an asset is capital.
Well, no, assets, my lord, are capable of being. Assets is a very broadly defined term, includes rights of any kind. So it can be in rem, it can be in personam, it can be shows as an action, it can be any number of things. It isn't, we say, something that falls within. It's not a non-exhaustive list, but it doesn't seem to fall within any particular category of these things. You're right, my lord, to say perhaps it may be services, but to the extent he provides services, his physical provision of those services is entirely within the member state. Well, we were a member state. It's entirely within the UK. And
that's the actual provision of services.
Absolutely.
But as my lord said, the right, which is the contract,
and if it were,
it is not in the member state.
Exactly. And so one might want to say that that is a provision of service, or the right to provide services. But then the provision of the freedom of provision of services is limited to member states only. So the fact that the right is transferred to a non-EU member means that it is not a right in respect that Mr. Hoey can rely on.
Well, what about the loans, which are associated operations?
And the loans, my lady, are payments of remuneration. So they are, we say, when you look at the facts, subsidiary. And if I could take you to Finnecane, that will help.
They're not. Then first, they're not capital, and secondly, they're subsidiary anyway.
Well, they are movements of money, so they could be capital.
They could be.
But there's a case called Louisi and Carboni, which says that it's not just the movement of the money that you have to look at, because if the movement of the money is in fact consideration for something else, it's the something else that is the relevant matter. And so we say that Finnecane looks at that principle and applies it. Finnecane was also, if I could just take you to that, perhaps, that might be a good thing to do right now. So it's a tab 59. If I could ask you to put the bundle back, the legislation bundle back, and take out the bundle which has tab 59 in it, bundle authorities. And my learned junior does remind me that it's out of house, so it's only persuasive.
Sorry, did you say 59?
Yes, my lord.
Doesn't seem to work.
It's
In
not
the
addition-
author,
in the main authorities bundle, my lord. Perhaps you have the additional authorities.
no, my tab 59 begins mysteriously in the middle of a
Oh,
page 1802. Maybe my bundle was full.
it's page 1782.
Oh,
Should be.
okay. 17.
The tab's been put in the wrong place, my lord.
I think
For which
that
one?
may be the answer. Yes, thank you. I think the tab has been misplaced. Right.
So this was a case of an airline pilot, and he'd entered into he was a foreigner. There was a loan scheme, and he was paid a small salary and he received loans. And the question was, how were they to be regarded for the purposes of EU law? And the arguments for HMRC are in paragraphs 20. Let me just take you to the parts of the decision. So if I could take you to page 1799, starts at paragraph 29, under the heading whether the loan charge constitutes an interference with the petitioner's right to free movement of capital. Article 63.1 of the TFU provides what it says there, and 65.1 provides a standstill provision and another provision. Then two separate questions arise at paragraph 30. The first, referred to by the petitioner as the threshold issue, is whether the petitioner's circumstances are such as to entitle him to the protection of the EU right to free movement of capital. The second is whether the circumstances of the case are such that as a matter of fact, that right is engaged, i.e. whether there is a movement of capital to which the protection is capable of being applied. There was no dispute regarding the first of those questions. As already noted, the petitioner is a non-UK EU citizen established in the UK and working in the UK for an Irish company. Whereas here, the right founded upon is a free movement right, it is unnecessary to identify a specific statutory provision implementing EU in order to found that right. The circumstances described are clearly sufficient to engage the petitioner's free movement rights, including the right to free movement of capital. It is unnecessary in the petitioner's case to address the question whether the interposition of an entity resident in the Isle of Man, a third country, for the purposes of Article 63 is of importance. It was not conceded by HMRC that a UK national would satisfy the threshold issue. And then the arguments are set out, 32, 34, 5 and 6, and then we've got the decision. At paragraph 37, page 1803. In my opinion, the petitioner has failed to establish that there is a movement of capital that engages his EU law right. In the absence of a definition in the treaty of the expression movement of capital, the decision of the Court of Justice in Louisian Carboni above provides a useful starting point. The question, so that is the question in that case was whether a physical transfer of banknotes was to be regarded as a movement of capital. The court noted that physical transfer of banknotes was included in the list of capital movements in the annex, and that's the annex to the nomenclature, to the then extant directives adopted in relation to movement of capital, but considered that this did not necessarily imply that such a transfer itself constituted movement of capital. In particular, the court held at paragraph 22 that it was not to be classified as a movement of capital where it corresponded to an obligation to pay arising from the transaction involving the movement of goods or services. In my opinion, there is a similar correspondence in the circumstances of the present case. The movements of money and services can be looked at in one of two ways. Taking a broad purposive approach, it could be said that the overall effect of the arrangements entered into was that the petitioner's services as a pilot were provided by him to Ryanair in exchange for the payments that the petitioner received from AML, consisting partly of a small salary and partly of non-commercial loans. So you will see that there's similarity there. On the basis of the court's analysis in Louise and Carboni, that is not to be classified as a movement of capital because it amounted to payment for services. On a narrower approach, it could be said that the petitioner provided service or services to AML consisting of his agreement to be being supplied as a pilot to Ryanair in exchange for payments in the form of a small salary and non-commercial loans received from AML. Again, in terms of Louise and Carboni, there is no movement of capital because payments from AML correspond to an obligation to pay arising from a transaction involving the provision of the petitioner's service to AML. And at paragraph 39, they quote Fidium Finance, or they cite Fidium Finance. This approach is consistent with the analysis of the Court of Justice in the more recent case of Fidium Finance. Fidium was a Swiss company, and then we go through that. And then, if I could take you to paragraph 40. By analogy, the present case is concerned predominantly with the petitioner's freedom to provide services. Regardless of whether the petitioner is treated as providing services to Ryanair or to AML, it is not argued that the imposition of the loan charge constitutes an unjustified infringement of his freedom to provide services. On either analysis, any restriction on the free movement of capital is, in my opinion, clearly secondary to the freedom to provide services, because it arises only as a result of the method of remuneration adopted in the arrangements entered into between the petitioner and AML. I recognise that the treatment of the right of free movement of capital as secondary in Fidium Finance was in the context where there was a restriction of the primary freedom. That, however, does not appear to me to affect the analysis that where one of the freedoms prevails over the other, the matter must be determined by reference to the prevailing freedom. And then if I could I think that is enough to make good the proposition that I have set forth here. Myler Jr. reminds me that, Mr. Hill reminds me about paragraph 43, and I could just take you to that. In summary, one comes back to the observation of the court in Louise and Carboni that movements of capital are financial operations essentially concerned with the investment of funds in question rather than remuneration for a service. I hold that in the circumstances of this case, the petitioner's EU law right to free movement of capital has not been infringed because the arrangements that he entered into through AML did not constitute movements of capital.
Do we happen to know if that case is going any further? And it was decided last year, I think, wasn't it?
Myler Jr. was actually involved in the case.
Oh.
I understand that we would have found out by now had there been an appeal. We don't think there is.
Thanks.
We recognise, of course, that this is only persuasive authority, but we say that the process of reasoning is consistent with Fidium Finance.
Yes.
And so we say, yes, of course, loans, the loans are made, but they are a method of remuneration for Mr. Hoey, and therefore engage, don't fall to be considered independently. They fall to be considered as a method of paying the remuneration for the thing that does primarily engage the freedoms, which is which is workers, but which of course he can't rely on because that doesn't apply to entities cited in non-EU member states. My Lord yesterday raised, my Lord, Justice Phillips raised the question of Fisher yesterday, just at the close. I wasn't quite clear what was to what you were referring, my lord, beyond that it wasn't. We didn't have a Court of Appeal decision in the bundle. Was there?
My recollection, but it's vague, was that there was an EU element argued in that. But that's a different issue.
It was an establishment issue, my lord, which we're not concerned with here, we say, because what is not being done in that case, of course, there was a whole business being set up in Gibraltar. Here, all he is doing is providing. He's entered into the contract employment with a third country and with an entity in a third country, and is providing his services under that contract in the UK. So there isn't an establishment of his services or his business anywhere.
Do we now have the Court of Appeal in Fisher?
We do, my lord, and we can hand it up to you.
I mean, obviously we can look it up ourselves, but it's a matter of form, perhaps.
Absolutely.
If it is to be before us, we should have it to add to the bundles. Thank you.
Apologies, it wasn't included. My Lord Junior, Mr. Hill reminds me that Fidium Finance has relatively recently been cited in Société Générale, and that's a case at tab 19 of the Additional Authorities Bundle.
Do you want us to look at it, or is that just
No,
one
it's
note?
just to it expresses the same propositions as Fidium Finance.
Paragraph number, if you've got it.
It's paragraph 19.
19. Tab 19 or paragraph?
It is tab 19 and paragraph 19.
Good, thank you.
And sorry, is that another decision of the Court of Justice? Or?
Yes, ma'am. Just for clarification, I understand that technically there was an appeal to Finnecane, but it's now been withdrawn or it's gone away in some way. Either way, my understanding is that it's not proceeding.
I don't think your paragraph number can be right.
Oh, is that right, my lady? Forgive me. Let me just.
No, I'm wrong. Tab 19 in the Additional Authorities is a reference about Hungary.
Yeah,
I think.
European Commission on Hungary is
Yeah.
what I've got.
Forgive me, it's tab 70. I must have posed the letters.
Sorry, tab.
So let me just find it for you, my lady.
Okay, thank you.
Société Générale, which we found, I'm afraid for my own friend, at tab 71 of the main authorities bundle,
Yes, I see.
and within it, the relevant passages are at 19 to 21.
Thank you.
So we say, my lady, that this is not a case in which Mr. Hoey can rely on any EU freedom, and the upper tribunal was correct in not in so holding. We then move on to if you're against us on that. In the present case, we say that the free movement of capital was subsidiary freedom to free movement of workers, and we note that the FTT found that paragraphs 141 to 143, and Mr. Hoey did not dispute, the relevant trigger for TOAA was Mr. Hoey's entry into the contract of employment. And I have taken you to the nomenclature to show you the sorts of things at which free movement of capital is aimed. And Mr. Hoey does not argue in his skeleton that the transfer of employment contract itself, or the rights under it, constitute a movement of capital. But in any event, we would say that transfer, the entry into the employment contract, fell outside the scope of Article 63. When one looks at the sorts of things that are considered to be movements of capital, it's not exhaustive, but it's, as the upper tribunal noted, surprising that something as generic as employment contracts wouldn't be included if it was intended to be a movement of capital. And that's at UT paragraph 270.
Well, that's for one reason. One doesn't normally think of entering into an employment contract as, in terms of, in the way that Lord Justice Hoffman, as he then was, looked at it in brackets. But here the whole approach we're looking at is whether or not entering that employment contract it is the transfer, or in this case, creation of an asset, namely an income-generating asset.
By which you mean the right to provide services under the employment contract, or the...
Well, that your whole case is
Yeah.
that the creation of the entry of the employment contract is the creation of an income-generating asset.
Yes, my lord. And it's absolutely. And what we're saying is that the transfer of assets provisions are broad enough to encompass this form of right being transferred, i.e., under the employment contract. But it isn't the sort of thing that comes within free movement of capital. I took you to paragraph.
Well, so the point I was responding to was that you were saying that it's not listed in the annex, the nomenclature of capital. The point I'm specifically putting to you is that, well, that's not surprising, is it? Is that one wouldn't, in most situations, even think of analysing an employment contract in the way that that your clients are analysing it on the basis of Justice Hoffman's analysis in bracket. So it doesn't seem to me it's particularly surprising that it wouldn't be listed in the annex.
I take your point, my lord. That's not to say that IRC in bracket isn't good law for UK purposes, but you can understand why. That's under national legislation. The nomenclature affects how the EU sees certain assets and certain contracts.
Then it's an autonomous concept of EU law as to what constitutes capital for these purposes.
Yes, and it's and as my learned friend reminds me, it's an autonomous concept within the transfer of assets provision, what constitutes an asset for these purposes. It's defined within that term. Yes, you may be right that one doesn't expect to see employment contracts under free movement of capital, but that doesn't mean that they aren't for the purposes of UK law. Employment contracts aren't transfers of assets; they clearly are. We say.
It's an unusual thing to move the right to provide your services in the United Kingdom to an offshore entity.
I didn't quite hear that, my lord. Did you say
it's an unusual situation where you're moving the right to provide your services in the United Kingdom to an offshore entity?
Yes.
It's an unusual situation.
Absolutely. Which is part of the factual matrix, we say, causes the transfer of assets provisions to be appropriate. Perhaps I ought to move on. So we then come to what we say next, which I have said already, but I'll just repeat under this head, as it were, is that because the movement of capital are, i.e. the loans, the transfer to the EBT by the employer, the loans to Mr. Mr. Hoey are movements of capital, that in and of itself doesn't mean that that is FMOC engaging, because that, we say, is the subsidiary, as it were, freedom. It is not the prevailing freedom. You don't have to therefore consider it independently. And it would be it would be inappropriate to allow, based on FII paragraph 100, to which I took you, to allow Mr. Hoey to rely on free movement of capital, because that would allow him to, the process of EU freedoms would be available to him, despite the fact that FMOC was not the primarily engaged freedom, and it would allow, as it were, access to EU freedoms exactly through the back door for third country entities. If you're against us on that, I then move on to consider whether we could say that you're against us on that, and you decide that free movement of capital is primarily engaged freedom. We have to try and show you that it's justified. The transfer of assets provisions are justified, and we say that in the if we are in the world of FMOC, which we do not accept that we are, then the concept of wholly artificial arrangements in the context of free movement of capital has a slightly more, a broader meaning than the Cadbury-Schweppes meaning. And we take that from the case of ex-GmbH. And if I might just take you to that case, my lady and my lords. It's at tab 70 of the main bundle of authorities. And the issue concerned the income of a company established in a third country, and it derived from holdings of debts by a company established in a member state. And the question felt to be considered whether this was a restriction on the free movement of capital, and then the justification. And if I could take you to where they talk about the third question. In the, this is paragraph 52, 167. And it starts page paragraph 52. In the light, in the event that the referring court should find, in the light of the answer to the question that the national legislation issue of the main proceedings does not fall within the scope of standstill, it is appropriate to examine the referring court's third question. By that question, the referring court asks in essence whether Article 63 must be interpreted as precluding legislation of a member state obtained by a company established in a third country that does not come from an activity of that company pursued on its own account, such as income classified as controlled company income from invested capital, within the meaning of that legislation, is incorporated pro rata to the amount of shareholding in the tax base of the taxable person residing in the member state, where that taxable person holds 1% of the shares in that company, and the income is taxed in that third country at a lower rate than the rate prevailing in the member state. I might say this was something similar to the CFC type scenario, except of course it's not controlled companies, it's just a 1% holding. Whether there is a restriction on free movement of capital is then discussed at 55. The court settled case law that the measures prohibited as restrictions on the movement of capital include those which are such as to discourage non-residents from making investments in member states, or to discourage member states' residents from doing so in other states. And then if I could invite you to consider to go to paragraph 70. According to the court's settled case law, a restriction on the free movement of capital is permissible only if it is overriding reasons in the public interest, and if that's the case, only if it is suitable for securing and attainment of the objective in question and does not go beyond what is necessary in order to attain it. In that regard, it must be recalled at the outset that I'm at para 72, that the need to safeguard the balanced allocation between member states of the power to impose taxes is a ground capable of justifying a restriction on the free movement of capital, in particular, where the national measures in question are designed to prevent conduct capable of jeopardising the right of a member state to exercise its powers. And then it talks at 73, in the same vein, the court has held that a national measure restricting the free movement of capital may be justified by the need to prevent tax evasion and avoidance, where it specifically targets wholly artificial arrangements, which do not reflect economic reality, and the purpose of which is to avoid the tax normally payable on profits generated by activities carried out in the territory of the member state. And it cites Cadbury Schweppes, as you'll see, and the ThinCap case. Para 74, moreover, the court has consistently held the need to guarantee the effectiveness of fiscal supervision constitutes an overriding reason. Relevantly, we say para 73 applies here because we have a situation in which we are seeking to deal with wholly artificial arrangements. If I could then invite you to move to paragraph 77. It cannot be ruled out, as observed in essence by the Advocate General at point 94 of his opinion. The opinion, by the way, is in the additional authorities fund where we thought it was inappropriate to not provide it to you in the main proceedings, and that in circumstances such as those in the main proceedings, the assignment of debts by Z, a company established in Germany, to Y, a company not subject to German powers of taxation, could result in the revenue generated by the activities of sports club carried out in Germany, to which those debts relate, being at least in part excluded from German powers of taxation, although the question of the substantive tax law applicable is a matter for the referring court to determine. Moreover, although the court does not have enough factual information for it to make a finding that in the present case the transactions at issue in the main proceedings are artificial, nor can it be ruled out that to the extent that Y's sole activity consists of holding debts purchased from a company established in Germany using funding provided by third parties, including a loan granted by X, the shares held by the latter in Y have no valid commercial justification, but rather X's primary objective, or one of its primary objectives, is to avoid the tax normally due on the profits generated by activities carried out in Germany by using Y as a controlled company for that purpose. 78. When legislation, such as that in issue in the main proceedings, by providing that the income of a company established in a third country with a low tax rate is to be incorporated into the tax base of a company with unlimited tax liability in Germany, is such as to offset, in a situation such as that in the main proceedings, the effects of any artificial transfer of income to such third country, such legislation is, in principle, suitable for ensuring the attainment of the objective which it pursues. It must further be determined whether the legislation goes beyond what is necessary in order to attain its objective. And then the court goes through the settled case law, goes through at 81, it talks about the wholly artificial arrangements in the Cadbury Schweppes concept. At 82, it should be noted that the court held in paragraph 67 and 68 of Cadbury Schweppes that the establishment of a company in a member state is a wholly artificial arrangement when it is demonstrated, based on objective factors that are ascertainable by third parties, that company is a fictitious establishment insofar as it does not carry out any genuine economic activity in the territory of the host member state, account being taken, in particular, of the extent to which that company physically exists in terms of premises, staff and equipment. The court inferred that such fictitious establishments, in particular those that have the characteristics of a letterbox or front subsidiary, can be subject to a specific tax regime for the purpose of preventing tax evasion and avoidance, and the treaty provisions on that theme do not preclude such a regime. That said, with respect to the question expressly raised by the referring court of what qualitative and quantitative requirements the shareholding held by the resident taxpayer in a company established in the third country must satisfy in order for it not to be regarded as wholly artificial, it should be borne in mind that the free movement of capital between the member states and third countries is intended not to frame the conditions under which the companies can establish themselves within the internal market, and then he cites referred to at 67 and 68 of Cadbury Schweppes, so not wholly fictitious letterbox type companies, that the establishment of a company does not reflect economic reality is the artificial creation of the conditions required in order to escape taxation in a member state improperly or enjoy a tax advantage in a member state improperly, can take several forms as regards cross-border movements of capital. Indeed, those indications may also amount to evidence of the existence of a wholly artificial arrangement for the purpose of applying the rules on the free movement of capital. In particular, and we say that in particular is an example, in particular when it proves necessary to assess the commercial justification of acquiring shares in a company that does not pursue any economic activities on its own. However, that concept is also capable of covering, in the context of the free movement of capital, any scheme which, by its primary objective, or one of its primary objectives, which has as its primary objective or one of its primary objectives, the artificial transfer of profits made by way of activities carried out in the territory of a member state to third countries with a low tax rate. And if I could just can I also just invite you to read 87? It is settled case law that as regards relationships between member states' national legislation, in order for it to be proportionate to the aim of preventing tax evasion and avoidance, must on each occasion on which the existence of artificial transactions cannot be ruled out, give the taxable person an opportunity, without subjecting undue constraints, to provide evidence of any commercial justification that there may have been for the transaction at issue. And they cite the ThinkCap legislation case. And what we say here is that XGMBH supports the position that in the context of FMOC, the concept of wholly artificial arrangements covers a wider variety of arrangements than just the Cadbury Schweppes type. It covers, in particular, any scheme which has as its primary objective, or one of its primary objectives, the artificial transfer of profits. And we say that when you look at the arrangements that took place here in relation to Mr. Hoey, those were transactions that sought to relieve him or sought to avoid tax. So they fall within paragraph 84 and the types of arrangements which have as their primary objective, or one of their primary objectives, the artificial transfer of profits made by way of activities to third countries with a low tax rate. Now, that, with third countries with a low tax rate, is, we say, one example of the types of arrangements. It's not meant to be exhaustive. And what happened in this case is that by way of the payment of loans through an offshore entity to Mr. Hoey, in respect of which no income tax PAYE was operable or operated, the position is that Mr. Hoey has achieved a tax saving, or sought to achieve a tax saving. That was the primary objective, certainly of the arrangements. We have a finding to that effect at paragraphs 153 and 154, and I think 160 of the FTT decision.
And it goes no further than necessary because there's the motive defence.
Exactly, because 87 gives him the opportunity to explain without undue administrative constraints. He can put forward any information he wants to do. He simply has to put it and provide evidence of it. So we say it's proportionate. Of course, my lady, I'm conscious of the time. Is this a convenient time for a transcribing?
If that's a good time for you, yes, that's very good. Well, it'll be 10 minutes.
Thank you very much. You might want to stay just in case I need to. Taking a note as well. Yeah, 25. Mind if I close that window? It's a bit chilly.
they think we don't know what we're doing. Well, I mean, there are amendments that look through to. What do you think about his last suggestion? I personally think we should have them there. The other reason why it's good is I think she's mostly US. As a US thing, so I think that would actually be quite useful. Yeah, yeah, can do. Yeah. Yeah, that last bit is just so stupid, isn't it? But it will be. They keep. They keep asking me to confirm if I'm going to pay the transcript cost. It's £2.5 grand. Forget about it. For each.
Oh, not here. We'll come back.
They're waiting. They're waiting. What? Definitely outside this.
Why do you take all the papers out of that
I've never found a way of making a LibreArch file last longer than a week.
without it collapsing?
Yeah.
Right.
It is like,
Doesn't mean it's difficult to paste.
My lady, my lords, I was going to go on to proportionality.
Yeah.
And in the first instance, we say that because there is the opportunity for somebody who is within the scheme of the transfer of assets provisions to rely on the motive of defence, it falls within section 87, paragraph 87 of the SGMBH. So there is a way around it to show that there is a commercial justification that this isn't avoidance, so that only the wholly artificial arrangements are caught. We recognise that that wholly artificial arrangements is as described in paragraph 84 of XGMBH talks about primary objective, or one of its primary objectives. We recognise that the motive defence talks about the purpose or one of the purposes. So it doesn't talk about the main purpose, but we say that that can be conformingly construed to include the main purpose and one of the main purposes. So, for example, if I were to take you to the legislation, which is behind tab 8A, you'll see under condition A, condition A is that it would not be reasonable to draw the conclusion from all the circumstances of the case that the purpose of avoiding liability to taxation was the purpose or one of the purposes for which the relevant transaction or any of them were effected. If it is thought that that is too broad when compared with even the ex-GmbH definition or meaning given to wholly artificial arrangements in the context of free movement of capital, because ex-GmbH talks about as its primary objective or one of its primary objectives, we say that this provision can be construed as if the word main was put in either before both the references to purpose or just for the second, because the purpose, we would say, is adequate to cover its primary objective. And one of the purposes, we say, could be read as one of the main purposes, so that it chimes with and is consistent with one of its primary objectives in paragraph 84 of ex-GmbH.
What about the fact that the charge is imposed in relation to associated operations? Does that make it too wide and go beyond what is necessary? Because
the charge takes account of a transfer of assets and the things that give rise to the power to, the arrangements that give rise to the income which the individual has the power to enjoy. We would say that that is all part of the arrangements. We do not see that as necessarily a disproportionate outcome, because that too is subject to the motive defence, which in the appropriate cases can be relied on. In this case, there's a finding that the purpose of the arrangements, the arrangements had avoidance aspects, and the arrangements therefore failed the motive defence, and that finding has not been appealed. So if we go to, just to make good that point, if I could take you to the FTP decision. It's core bundle tab 17, paragraph 153 to page 321 of the bundle, tab 17. We start at paragraph 152 perhaps. However, in this case, I cannot believe that Parliament intended that taxpayers should be able to set up offshore employers who would make contributions to a trust, which would then make loans to the employee, who did not expect to be required to repay the loans, and who would then be taxed on the notional benefit of receiving an interest-free loan rather than on the benefit of receiving the monies in a form which was taxable as income. I therefore regard the basic structure of contractors being employed by an umbrella company, which then provides their services to the end users, as being a perfectly reasonable commercial transaction. However, I regard the insertion of additional transactions, including the setting up of an umbrella company offshore, which makes payments to a trust, which then makes interest-free loans to contractors with the expectation that those loans are never repaid, as constituting tax avoidance. I am not required to ignore those transactions in my analysis. Using a purpose of analysis, I find that their purpose was the avoidance of tax in a way which Parliament did not intend. And then he went on to consider condition B, that the motive defence has failed in relation to condition A. So we would say that from the arrangements in this case, the achieving of the tax advantage for the employee, we say, was the main purpose.
well, he finds at 156 that it was the purpose.
Exactly. So the motive defence is not available to Mr. Hoey in this case. So there is no need to conformably construe on the basis of ICM problem. just to remind myself, ICI and Colmer states that there's no need to conformly construe when the facts themselves don't amount to a breach. ICI and Colmer is in the bundle, and it's at paragraph 34. I don't intend to take you to it, but just the old note, my lady Margaret.
Tab 34 or paragraph 34?
Paragraph 34, it is tab
62.
62.
Thank you.
We recognise, however, that it may be possible that these provisions apply and another set of provisions apply. And the question then is, how does one deal with perhaps a double charge that may arise? And what we would say is that when one looks at the provisions of section 743 sub 1, if I could take you to that. That's page 488 of the bundle. That's the legislation bundle. That is a provision within the transfer of assets provision. It's headed no duplication of charges. Sub 1 states no amount of income may be taken into account more than once in charging income tax under this chapter. Now, that is capable of having two readings. One is that both charges on income arise within the chapter.
Yeah. That's how I
Another
read
is
it.
that one charge arises outside the chapter and the other charge arises within.
But doesn't subsection 2 reinforce the first reading?
It is a species, it's an example of how the first could be read, of one reading of the first. It doesn't necessarily exclude the second, because it covers, we say, both possibilities. It's certainly capable of covering both possibilities. So one could read it as saying, no amount of income may be taken into account more than once, whether it's within the chapter or outside this chapter, in charging income tax under this chapter.
So that would reinforce the concession you've now made that this is a fallback provision. If the ITPA charge takes priority.
But it's different income that's being charged.
Yeah.
That's true.
Yes, and
That's the basic
the problem.
problem, isn't it? We've got two different types of income. Apparently, both, if your submissions are right, both falling within different sets of charging provisions.
And what we would say, my lord, is that there are indications within the transfer of assets provisions themselves that show that there is no intention for there to be double charges.
Well, I'm not sure about that. And one of the problems is this was avowedly penal legislation, not just anti-avoidance.
Well, my
I mean,
lord,
it's a very odd set of statutory provisions. They go back a very long way. And the early authorities, as you know, I mean, they describe it as penal, intended to actually act as a penalty, not just to combat tax avoidance. That's one reason why it needs to be handled with such care.
my lord, what we would say is if one looks at 743 sub 4, that also gives an indication that there is no intention to double charge within the provisions. So if one were to construe it as we suggest it is construed, i.e. 743 sub 1 is construed,
Yes.
it doesn't go against the grain of the legislation. Equally, and the concern about it being different income, if I might just take you to paragraphs, section 746.
Yes, but before you do, I mean, actually, talk of a double charge is, in a sense, a slight misnomer. I mean, true double taxation would be having the same income subjected to two separate charges. Whereas the concern here is one has economic double taxation. It's not the same income. It was, in the old days, it would have been assessed under different schedule. I mean, just before I forget, I mean, can you remind me, in the old days, tax under transfer of assets abroad was assessed under what schedule? Was it case? I would guess it was case 6 of Schedule D.
Well, I think it may have been under case 6. It certainly wasn't under security for possession.
No, and it certainly wasn't certainly wasn't under Schedule E. So they were entirely different heads of charge on different income.
My lord, one of the reasons we are proposing this as a possible conforming construction is because there is a presumption that Parliament doesn't intend double charges. It's a presumption that is, we say,
yes,
made out in cases.
I mean, yes, there's a presumption against true double taxation. But I was just saying we need to be a little careful because this isn't true double taxation. But it is economic double taxation, which is not subject to quite the same presumption, I don't think.
My lord, I think one needs to perhaps look at it in these terms, that the concept of presumption is that Parliament intends to act reasonably, of which there is a sub-presumption against taxing a person twice in relation to the same matter.
Yes, same matter, yes.
And we say that that presumption can be interpreted in such a way as to ensure that the economic burden doesn't fall twice. And we say that such a reading does have some support from the fact of the existence within the Transfer of Assets Code of Section 746, because that, as you see, allows the same deductions of reliefs as would be allowed if the income treated as arising to the individual under 721 had actually been received by the individual. So it deals with that, we would say, that it's not the same income point. My lord, there are other indications within the code, we say, that also show that there is an intention not to double charge. If I might also show you 744, which supplements 743, references in 743 sub 1 and 2, no duplication of charges, to an amount of income taken into account in charging as follows. In the case of a tax charge on income under 720, if 724 benefit applies, they are references to an amount of income out of which the benefit is provided equal to the amount of value of benefit charge, so you don't get a charge on both bits. Otherwise, there are references to the amount of the income charged. So if you have an income that is charged, you don't then have a second charge. We say that that is an indication, again, that this legislation does not intend to impose double charges. So that reading the legislation as reading 743 sub 1 in the manner that we propose is not going against the grain of this legislation. And we say that 746, together with that, does show that the Parliament is trying to deal with that mismatch between the amount treated as is being a different source of income to the income that is the income of the person abroad.
Well, and I see the point you're making. I'm just wondering, perhaps to myself, whether that it really is the right way to construe what was always intended to be highly penal anti-avoidance legislation. I mean, and as you said yourself yesterday, it's a self-contained code which has its own rules, and where it applies, is intended to have a deterrent effect. In that situation, one finds as it were, around the margins, various provisions designed to lessen the burden. But if one can actually elevate that into a kind of parliamentary intention that there shouldn't be any element of economic double taxation, I think that may be a step too far, given the very odd type of legislation we're concerned with. It's avowedly penal anti-avoidance.
Nothing on the words of the statute actually says it is a penal provision.
Well, isn't that, what about the preamble? What the preamble has now been turned into?
It's
An extraordinary, clear statement of parliamentary intent.
this is opposed to cosmic income tax, individuals on whom income is treated under 721 is rising. And then at 720 itself, the charge under this section applies to the purpose of preventing the avoidance of liability for income tax by individuals who are ordinarily UK resident by means of relevant transfers.
Yeah.
And it applies thereafter in terms set out in section 720 sub 2. So it isn't on its face intended to be penal.
Is that was early judicial interpretations of it, and it was Lord Green in one of the early cases in Howes and Walden, as far as thinking of
Doesn't
it.
lie in the mouths of those who complain of who gave a fart
burnt
and
fingers
burnt.
and all that. Yes.
Exactly. But we would say that that may be the interpretation of these by the courts, but the provisions themselves apply where they apply on their own terms. Forgive me, my lords, I just want to clarify one point with those sitting behind me before I say anything further on this.
It is the same income, isn't it? If you look at the conditions of enjoyment. Isn't it? I don't know. Maybe it isn't.
Because it's a deemed,
Yes.
it's a measure of the deemed income which arises to be under this code.
Yeah. Okay.
I agree.
So I'm grateful for your indulgence on that. There is one other way of a slightly more muscular way of performing this provision, which does involve adding in some words and taking out some words. And perhaps if we could essay it like this. So when you look at section 743 sub 1, and if you were to remove the words under this chapter from the end of it, and to add in the words in relation to the same individual between the words account and more, no amount of income may be taken into account in relation to the same person more than once in charging income tax.
So I'm not,
That would
not sure
prevent
what-
a double charge on the individual.
what exercise are we engaged in?
This would be
Conforming
a more
construction.
muscular conforming construction.
I
One
think
of our
lost
basic
that.
ones.
This is to conform with what? To conform with EU law.
Yes, ma'am.
So on any view, this will be no use going forward because Obviously, we're no longer in the EU.
Because double transfers doesn't go forward. Novel. Don't like that statute.
Those behind me remind me of the fact that EU principles are still applicable because going forward because of provisions within the EU Withdrawal Act, which we
Fundamental principles
exactly the fundamentals
continue to
apply. Of course, we only come to this point if you're against us on FMOC not being engaged in the first place. And also, of course, but we don't have it in the bundle. We will bring it along tomorrow when we convene. The legislation has in fact been amended in 2013, is my understanding, to remove some of these infelicities of double charging and the like. But I can't take you further on that because I don't have it in my head and I don't have it to hand. But the changes were made by the Finance Act 2013, and we can bring copies of the amended legislation in when we come in tomorrow. And if you're against us on any of those bases of conforming construction, then the next step is logically disapplication. The question is disapplication of what? And we would say that the only provisions in respect of which the EU freedoms are claimed, the EU protections are claimed, are the transfer of assets provisions. And so they are the ones that ought to be disapplied, should you get that far. But we, of course, contend that you don't get anywhere near this.
Do those sitting behind you know which section of the Finance Act 2013?
Forgive me, my lady. I didn't-
Which chapter or section of the Finance Act
I'm afraid
2013?
I'm just looking.
Oh, is it chapter 2, section 26?
My junior is just looking it up.
There were amendments made to section 721 and section 734, but I can't remember.
Schedule 10 amendments.
743 and 721 and the
I think it's Schedule 10.
Is it Schedule 10, my lady?
think so.
My junior to it.
Right.
Those are our submissions.
Thank you very much. Stephen. Yes, Mr. Mullen.
Thank you, my lady. My lady, I'm proposing to reply in relation to the response in respect of our appeal in relation to the judicial review and the jurisdiction issue, firstly, and I'll do that today, and then tomorrow I'll deal with responding to the transfer of assets abroad issues.
Right. I expected you to do it the other way round, but if that's the course you wish to take.
Oh, I'm sorry. I'm sorry. I'm happy to do it the other way,
No,
but
no.
in terms of the timetable, I think
That's
the way.
that's what you were intending. I'm so sorry. Yeah.
Just one point which I'd like to make clear, because it sort of came up a few times yesterday, and that's that the claimants in this case are not the promoters of these arrangements. They're not acting on behalf of promoters, they're not funded by the promoters, and actually they've got no insight into
We understand.
why the promoters did what they did. And so, unfortunately, I know there were some questions about why the arrangements were structured the way they were. And while I can certainly speculate, I've got no more insight myself. But I would say in relation to the PAYE, having the arrangements offshore doesn't seem to me to improve the employee's PAYE position at all. If this was all done onshore, the same consequences would have followed, whether the scheme had worked or not. Rangers, after all, was an onshore structure.
Well, but for Rangers, an offshore employer doesn't have to operate PAYE.
Yes, but someone would, and certainly there would have been the liability to income tax. And the liability to income tax would have been on the income received and the benefit of the loan, and that was what was paid, and that was how the arrangements were expected to work.
Yeah.
From the employee's point of view, sorry, the point really is that from the employee's point of view, tax liability, and using it in that term, leaving aside PAYE, was unchanged whether the employer was offshore or the employer was onshore. So having the employer offshore seems to be sort of mainly for the benefit of the employer, presumably corporation tax, NICs, although I think there was an issue with that in the Isle of Man. But certainly it doesn't benefit the employees in any way. And simply I don't understand, or I don't say I don't understand, but I don't know what the reasoning behind not having a tax presence in the UK was, if that was related to PAYE or not, or whether that was more related to the corporation tax issues which might arise. But I simply mention this because I think it was my Lord Justice Henderson raised the point yesterday as to why it was done the way it was. And one can speculate, but it doesn't seem that having it offshore would have been of benefit to the employees. I think there was also a question as to why the offshore employer actually did pay PAYE on the bits which were understood to attract PAYE. Again, I don't know, and I'm only speculating, but I suspect it was to reassure people like the claimants entering into the arrangements that all the tax which should be paid was being paid. But obviously, as the arrangements didn't work, and as things have turned out.
The marketing makes a big point of saying it's a UK registered employer.
Yes, obviously to put people at ease, to persuade them to enter into the arrangements, because that was the way in which the promoters made money, by getting people to enter into these arrangements.
And it's all above board.
Yes, and people won't do it if they don't think it's all above board. I think there was a degree of criticism about the evidence of the claimants in relation to the judicial review claim. The point I'd make there was that it hasn't taken place in isolation. Obviously, we've got two joint appeals here, and it was very much linked to the first-tier tribunal proceedings, where we had very full findings of fact.
Sorry, what are you addressing?
The criticism that, in terms of the judicial review appeal, evidence hadn't been provided in relation to what the arrangements were.
Ah, I see. But nor was it provided in relation to the statutory appeal.
Evidence, well, as much evidence as possible was provided in relation to the statutory appeal. And I think it's important not to lose sight of the fact that HMRC have very extensive investigation powers, and in fact had used them and had apparently got lots of information from Penfolds, some of which was deployed in the appeal. You can see from some of the documents they have a stamp showing they came from the Isle of Man. But
Contract of employment, for example, was never supplied.
No, it wasn't.
That could have been supplied.
Well, I think certainly Mr. Hoey had supplied everything which he had, bearing in mind that this all related to some period ago. In terms of the contract of employment, we've just been discussing transfer of assets abroad. Sort of one answer to is there a transfer of assets might have been, well, there wasn't a contract of employment. Sort of we conceded that point. So it wasn't that we were seeking to take the benefit of the lack of evidence. Effectively, it was common ground how the arrangements operated, and that wasn't disputed. So,
well, common ground that there was a contract of employment, not necessarily common ground how the arrangements operated.
Perhaps if I say common ground on the factual basis rather than the technical basis.
Why don't we have the contract of
As I understand it, it's been lost. It was some years prior, and it was obviously signed. And while it would be nice in an ideal world that people keep all the papers that they sign and do,
all of the contracts with all of the claimants have been lost.
I can't speak to that. So I was speaking more in terms of the statutory appeal, and certainly in
But
terms
it's a Rule 18 appeal.
Exactly. I mean, surely one or more of the follower cases, it would be a fairly simple inquiry to ask whether any of those could supply.
yes, but
It,
I
it's not a central document.
well, it is insofar as there was a contract of employment, but it's not disputed there was a contract of employment. It's not disputed that the terms were essentially you were paid an amount, and there was an expectation of getting a loan. So,
Without seeing it, how can we be sure what there was an expectation of?
well,
I mean, except by a priori guesswork.
yes, but I think it was the revenues case that there was an expectation of a loan. So, I think if we'd wanted to take an alternative case, of course we would have had to provide it. But in circumstances where a proposition has been put forward, it's not been disputed, the evidence in those circumstances, I think, takes on rather less importance.
And I suppose we can get some help from the DOTES disclosures. I mean, that shows that was all intended to be set up.
Yes, and there are employee handbooks which sort of explain about that there would have been contracts, and there was agreement as to, sort of as set out in the first tier tribunal decision, as to how it all worked as between the EBT, the employer, contractor, and the end user. And I obviously accept the other claimants haven't given evidence. I think there was originally a much bigger class of claimants, which are broadly people who have an interest in this. And as a result of a pragmatic suggestion by Lady Justice Andrews, that was whittled down to effectively the people who've had decision letters. As no one has given evidence that they can prove the end users knew of the nature of the arrangements, obviously it's a fair inference that they're not in a position to do that. I don't dispute that. But I don't say it's a fair inference from the fact that they can't show that the end users knew of the arrangements, that necessarily it follows that the end users didn't know of the arrangements. The reason being that the end users have other sources of information which we just don't know about. But a major one, and this follows from the contract which we got yesterday, is the recruitment agencies they deal with. So,
Well, and Mr. Hoey and the other claimants.
Absolutely.
And we've got no evidence from them.
And I accept that it's a fair inference that they're not able to show that they did provide that information because we have no evidence. What I'm saying is it doesn't follow from that automatically that they couldn't have known about it because they could have been told by someone else.
Well, that's just speculation.
Well, absolutely it's speculation, but it's equally speculation that they didn't know. The purpose of the two witnesses was, and they are people who are in a similar position, was to show that it's not the case that in every situation the employers didn't ask or didn't know. I accept that they're not actually claimants to this
They're in very different situations, aren't they?
Well, I think one was a director. I'm not sure, given that he was showing an email requiring him to provide something to someone within human resources, that's particularly relevant to that. The other one wasn't a director. It was just the nature of the business and the company he was in that he was required to provide the information. Yeah. Now, the particular subsidiary he worked for happens to have been wound up, but I think that's neither here nor there, and given that he was working for sort of a massive group of companies. The point remains that...
We've got no similar evidence from Mr. Hoey or any of the other claimants.
Yes, but...
It just doesn't go anywhere, does it?
Well, it doesn't go anywhere insofar as if Mr. Hoey or the other claimants were in a position, now they know what the guidance is, and we're in a position to show, well, actually, the employers definitely knew, then a very short answer, I would have thought, would have been to provide that to the revenue.
Well, even now they could have provided evidence.
Yeah, sorry, that was what I was accepting. Yes, but there's a gap between what they can prove as employees and what the employer knew.
The end user knew.
The end user knew, and that's my only point.
Okay.
Yeah, the point about Albury hired, it shows Aviva using an established recruitment consultant, and in those circumstances, there is going to be a level of expertise, certainly among the recruitment consultants, as to what the tax consequences following on are, the potential risks in relation to Section 689.
Why?
Well, one would expect that that follows as part of being in the business of providing employees to end users.
But why shouldn't we infer that they were told Penfolds and Hamiltons are operating PAYE?
Well, I think that the inference where it can be drawn is, I would say, clause 1.7 of that agreement, which contains an indemnity in relation to tax. And you wonder, well, why is an indemnity in relation to tax in there? The obvious inference is because they realise there's a potential tax issue. The other point I'd make about that, my other friend made a point about, well, it says you can't tell your employer anything about the contract. It doesn't, anything in that contract does not prevent Mr. Hoey from telling the employer, telling the end user about who his employer is, or about the fact that he was paid by way of loan. For the simple reason that, as my other friend pointed out, that wasn't information which was in that particular agreement. If they'd asked, he could have told. But this and the wide extent of HMRC's information powers, we say, goes to the reasonableness of their approach in investigating, in that it's very easy for HMRC to write to an end user going, we have details about this person who worked for you between these dates. Did you know about their arrangements? And the end user can write back going, yes or no, or we delegated that to our recruitment consultants. That's a simple matter. It's much easier for the revenue to do that than it is for an individual contractor who may have been fairly low down the food chain within a company to be able to find out these things.
So the revenue doesn't know who the end users are?
Well, they do when they ask, and the criticism was made of Mr. Hoey that he hadn't told the revenue until 2015. He was asked in 2015 who his end user was, and he replied within a month, giving the details to that and lots of other questions. So, again, it's not something which was being withheld. And, of course, we were taken to the DOTAS disclosures. They were made in 2004. So as far back as 2004, the revenue knew exactly what was going on. And the revenue certainly must have known, given the offshore nature of the employers, that there was a risk to end users. And we do know there's a mention in the internal manual that employers were expected to do due diligence to establish whether they have PAYE obligations or not. So at that stage, there was a level of expectation among the revenue. So that's all I want to say on the evidence. Before responding to legal arguments, I'd just very briefly like to address the relevance of Lord Dunedin's classification of the tax system in Whitney. Now, that was a statement made in 1926 in the context of a case about an assessment on a non-resident. So it was made before the introduction of PAYE. I think there's no doubting that it is a useful observation. But at the end of the day, that's all it is an observation. It's not statute, and it's certainly not some sort of sacred statement as to how the tax code must be chopped up. I think the point has been made by Lord Justice Henderson in another case that the tax code today is certainly more complex than it was in Lord Dunedin's day. And I think that has to be borne in mind when one considers what has been said. So while it does offer useful context, it's not necessarily helpful to try and make particular provisions conform to what Lord Dunedin was talking about. And in the course of the submissions, I did use, at the urging of the court, the terminology of an obligation to pay to distinguish from the terminology of liability. Just to be clear, I was trying to be helpful in terms of definitions. I think it's quite clear that an obligation to pay is, in everyday language, people's normal understanding, that is a liability. So I'm not for a second suggesting that there isn't a liability in the normal sense of the word, but by agreeing to that. And when, for example, I made reference to the primary liability being on the employer.
Employee.
Well, no, the primary liability is on the employer, and that comes from the ITEPA explanatory notes, which, if you remember, I took you to. So in relation to section 13, what they said was setting out that the liability of the employee, the liabilities on the employee is new, but the primary liability remains with the employer under the PAYE system.
But the wording of explanatory notes is not endorsed by Parliament. It is just departmental guidance, effectively.
Yes, but it's equally there to assist
You
Parliament.
accepted it was background yesterday. You showed us.
I do accept its background, but I say it's very relevant background.
Well, we've got to look at the statute, don't we?
Absolutely. But I do say it's very relevant background, and I do say that, just put it at the very lowest, I'm not alone in suggesting that the main liability, using that in the non-technical sense, is on the employer.
I hope I made it clear when I made my points to you yesterday morning, but I entirely accepted that as a matter of ordinary English, one can use the word liability quite naturally to refer to the obligation to deduct PAYE. It's just for the purposes of analysis. It helps to distinguish between the underlying liability, which is imposed as a matter of law on given income, and the collection machinery, which involves these obligations to deduct an account.
I absolutely accept that, my lord, and you did make it clear, which is why I was happy to adopt the difference of approach. It was more comment on my little friend's submissions.
Okay.
In terms of the inability to assess the end user, no convincing reason was given as to why it was inappropriate to require the end user to comply with PAYE regulations, which after all is a statutory test, in circumstances where HMRC were out of time to force compliance. There seemed to be a suggestion that there was a possibility of assessing end users in time. The question was whether, as they decided, it was inappropriate to do so and instead to collect money directly from the claimants. And that was why HMRC had decided not to issue Regulation 80 determinations. I think it's important to note that the years in question we're dealing with end in 2011. The CIP policy came into effect, well, was made in September 2017. So at that time, HMRC were out of time to assess end users. Interestingly, when Mr. Hoey informed HMRC of who the end users were in 2015.
When you say assess, you mean by a Regulation 80?
Yes, by a Regulation 80 determination. So I think there is a case where it was argued that it wasn't an assessment for certain purposes. And,
yeah, I was just checking that that's what you were talking about. Yeah.
But yeah, interestingly, when HMRC were informed of the end users, that was February 2015. They would have been in time to issue Regulation 80 determinations then, but it was only later that they came up with the alternative policy.
And Rangers wasn't decided till 2017.
Yes, I think that's right. I think and I'm not sure of the dates, but the Court of Session had decided along similar grounds sort of shortly before that, which I think was the first time when that redirection argument had been made and accepted. Which brings me then to the list of reasons which were given as to why end users shouldn't have to meet their tax obligations. We had HMRC didn't know the end users as they weren't identified in self-assessment. Well, there's simply no obligation to identify an end user in a self-assessment. And the whole point about PAYE, the whole point about self-assessment is that companies are responsible for their own liabilities. And as I mentioned, HMRC had made clear to companies that they needed to carry out due diligence in terms of their PAYE obligations. Then there was that the end users wouldn't know what their obligations were. They didn't know how the remuneration was being paid, which, while it might be true, doesn't necessarily, we'd submit, justify not meeting a statutory obligation. It's not one which many taxpayers get to run as an answer. Then we had that they might appeal if HMRC has issued a determination against them. It wouldn't be fair to put end users through hoops because after you'd issued a determination, you might decide to go by Regulation 81 anyway. Yep. And they weren't aware of their obligation to operate PAYE, i.e. they had legal obligations, but they didn't know what they were. And all of these were given as explanations as to why it was appropriate not to require someone to operate PAYE. And what I submit is that's quite relevant, not only in relation to this case, but in relation to all the cases going forward where a company has an obligation to, or an employer has an obligation to operate PAYE, and for whatever reason hasn't done so. Is it open to them to go, well, actually, we didn't realize that we had to. It's a bit unfair. If you assess us, we'll appeal. And what are HMRC going to do when faced with that? Which does, I think, raise an important point which the court does have to engage with. By construing the legislation in such a wide fashion, HMRC are effectively opening a Pandora's box of problems for themselves. How will they ever be able to enforce collection from an end user in circumstances where it's a bit unfair?
That's how you characterise it, a bit unfair.
Well, that seems to be...
The arrangements involving the insertion of an offshore employer with payments into an EBT, some PAYE deducted from salary to give the appearance of respectability and that it was all above board, which I think you just accepted. You characterise that as a bit unfair.
No, Mylene, I wouldn't characterise that because that's not what I'm characterising.
Well, that's what it was, that package of arrangements that led the officers in this case to take the view that it was not appropriate. It's not simply that the employer didn't know, which I think is how you were.
Well, I think the way it was being put, it did seem quite a lot like the employer didn't know, and I think this is quite important as to, well, why is it not appropriate for the end user not to be paying? Because if it's not appropriate in this case, the next time when someone comes along and goes, well, actually, you let all those people off, why can't you let us off? There are going to be arguments about it. And one of the, I think, benefits of the way in which the tax code is structured, that the revenue are really quite limited in terms of what they have by way of discretion when it comes to paying tax, that they're in a position to go, yes, this might be terribly unfair, but this is what the law is, and you can go off to the tax tribunal and fight it. And they're not constantly being challenged, they're not constantly subject to judicial reviews going, yeah, but you should have treated me differently, it was a bit unfair, can you not use something different for my circumstance? That benefit is lost once you say, but in the context of PAYE, we've got this really wide discretion which allows us to decide on a case-by-case basis, is it necessary to apply PAYE? And bearing in mind what we're saying about the liability being with the employee, is it ever necessary to apply PAYE? Because you can always just go after the employee. And one can imagine that argument being deployed in a whole range of cases and a whole range of circumstances where employment income charges come up. That's why I said it is a Pandora's box. There is a huge range of problems which potentially arise out of having this wide discretion, which the current structure of the tax system neatly avoids. And the sort of elegant reference to St. Matthew may allow us to try and avoid the issue, but with respect, it is an issue which is front and centre and one which this court needs to grapple with. So I think that's a general point of quite considerable importance in the context of why the legislation shouldn't be construed so widely, and equally why Parliament might be taken not to have intended such a wide discretion. In terms of the specific construction points, on the general and the specific, there was a point made that because section 6842 is permissive in terms of what can be included in regulations, it's not intended to cover everything. Just to remind the court, the provision which says that they have to cover everything is 684 subsection 1, which says that the commissioners must make regulations covering not only asset collection, but assessment, collection, and recovery, and in respect of all PAYE income. So that could not, in my submission, be more clear in the terms that it's supposed to be. Very wide. I did address the court on the Cusack case, which was relied on in the Higgs case. And the point remains the same, that there we were looking at two overlapping specific provisions. Here we have a very general wide power and specific provisions contained in item 4A and the directions made under it. In terms of retrospectivity, that argument seemed to turn in part on the claimants never having claimed the tax credit in their return. And on that basis, it was said they were never entitled to it. Now, the reason for this, of course, is that they had been advised that there was no PAYE liability. And it was only in the light of the Ranger's decision that they were advised that actually that was wrong. And there was a PAYE liability. But the situation which actually prevailed in law throughout the period was that the claimants had had an obligation to pay an amount of tax to HMRC. That obligation reflected a credit in relation to the amount which ought to have been paid by the end user. That right arose as a matter of law. It didn't have to be claimed. And then the question is about the scope of the power and whether it can retrospectively deprive a person of that right. Now, with respect, it doesn't matter if a person knows they have a right in terms of whether they ought to be retrospectively deprived of it or not. The presumption is the same regardless.
But the same would have happened if they'd exercised a Regulation 81, if they'd
Yes,
Regulation 81.
This is what I'm going to come on to, because what I rely on is a presumption against retrospectivity. Now, the critical word there is it's a presumption. It doesn't apply in every case. The presumption can be rebutted by clear words.
Regulation 81 is a pretty clear indicator.
Well, absolutely. But Regulation 81, I say, can retrospectively remove the right, as can Regulation 72 and 72F. And it's absolutely clear the way they operate, the way they interact with Regulation 185 and 188, that that is what they were doing.
So why doesn't 7A operate in?
Because it does not have the same clear words taking effect. So what you can't do is go, well, we have these clear provisions retrospectively removing the right, therefore these vague ones have the same effect. The presumption applies to the general words. The presumption has been displaced in relation to the specific words. And a slightly related point, it was suggested that once you exercise the power to relieve the payer of his obligation to account for PAYE, then normal liability kicks in. With respect, that overlooks regulations 185 and 188, because you have not disapplied regulations 185 and 188, which have got nothing to do with the payer. And it's the clear words of those regulations which mean that even after you've relieved the payer of liability, the credit is still good. And it's only where you actually use the directions regulations, if I call them that, which say actually your credit's removed, and do that in very explicit terms, that you then lose the credit. But when you don't use those directions regulations, then the credit remains. And that's a point which I think is even clearer when you get to regulation 188.
Just to look at it.
I think it's helpful to have a look at it. Page 325. Now, it's the context of subparagraph 5. And sorry, actually, before we go to this, it's probably helpful to look at, my learned friend handed up section 30A of the Taxes Management Act yesterday.
Yeah.
And one of the things which we can see from that is 30A subsection 4. After the notice of any such assessment has been served on the person assessed, the assessment shall not be altered except in accordance with the express provisions of the Taxes Act. So you need an express provision to alter an assessment.
So we've got an assessment that includes all the income.
Yeah, sorry, I don't say we rely on that in relation to the assessments here, because the assessments here clearly include all the tax and all the chargeability.
Yeah.
But what I refer to that to in relation to is it explains why you need regulation 188.5, because that is an express provision amending the assessment.
It's about if a direction is made.
Yes, so as my friend explained yesterday, there's the situation where you have the direction before the assessment,
Yep.
and that's all relatively easy. But then you have the situation where you have the direction after the assessment, and that's what this is dealing with. So if a direction is made after the making of the assessment, so we've got an assessment made, the amount, if any, shown in the notice of assessment, so we're assuming, well, and this is the point which I made in respect to jurisdiction, there must be an amount shown in the notice of assessment as a deduction from or credit against the tax payable under the assessment. Now, tax payable under the assessment is a defined term. It doesn't actually mean the tax payable under the assessment. It means, as we see, the amount of tax shown in the assessment as payable without regard to the amount shown in the notice of assessment as a deduction from or a credit against the amount of tax payable.
So those are two different things.
Yes.
One is about collection and the other is about liability.
Well, I think going back to Hallamshire, you need both. But what tax payable under assessment, I think, sorry, I apologize, you're right. Tax payable under assessment is liability.
And that's what's shown in the 29 assessments or the 28A closure notices.
Yes, but and obviously the bit which we complain about is that they don't show the correct amount of tax payable, because we say they ought to give credit for the amounts which are required under Regulation 185 and 188. But so you see the tax payable under the assessment, i.e. the liability, is technically reduced by so much of the direction tax as was included in calculating the amount of tax referred to in 3A. So basically you make an amendment of the assessment by reference to the direction tax. And the reason why you need to do that is because you can't amend an assessment without an express provision. And one of the problems with 7A is it's not an express provision. So it wouldn't achieve that. So that's a very clear indication that the direction tax is intended to have the function of removing the credit, but it's the only one. And that's consistent with the statutory scheme. In terms of the linguistic arguments, if we say, on the retrospectivity, I've made my points in relation to this. I think it was very neatly set out by Judge Morgan in the Lancashire case. But I think a point which was made yesterday was, if you look at A and B together, and one's doing amending and the other's doing, well, you don't have to apply at all, it does become even clearer, because A is very much operating prospectively. It's paragraph A and B of subsection 7A. And in terms of the criticism of the upper tribunal on retrospectivity, we just submit that those criticisms were misplaced. It's absolutely clear when you read what the upper tribunal were saying, what they meant. And the reasoning was equally applicable to sums which weren't deducted as sums which ought to have been accounted for. And of course, you've got the two defined as tax, treated as deducted, so it's an understandable shorthand. The next point I wanted to make was in relation to section 222 of ATIPA. Now, Mr. Grudzinski, in response to a question from Lord Justice Phillips, stated that the reason why liability for the employer followed from the relief for liability employee was that, and I took this from this transcript, that if it were otherwise, and this is an important principle, the well-established principle set out in cases like Preston, namely that the primary duty of the commissioners is to collect tax, not to forgive tax, would be violated. Now, I have to say I agree with that, because it very much mirrors a submission which I'd made, that the scope of the power has to be exercised consistently with HMRC's general powers. And it's also relevant to the point about the principle of legality that HMRC can't exercise a general power to forgive a liability. And we say that must be correct. But what's interesting is sort of what then happened when we got to talking about section 222. Now, section 222 imposes a liability to tax, and I mean a liability in the stage 1 sense of the Whitney classification.
Yeah.
What HMRC say the exercise of the discretion does is forgive that liability.
I don't think they. I think they say that that's as a result of the wording of section 222, not as a result of some sort of concession.
No, it's not as a result of a concession. What they say is we exercise the discretion.
Yeah.
That
Can't
switches
remember
off.
which subsection it is. Should we just look at it?
Yeah, I think probably we have to go through a few sections to.
Just remind me where 222 is.
At page 222.
Yeah. Yeah, it's because of B, isn't it?
Yes. So
Yeah.
the point being, or the revenues argument being, that you exercise your discretion under 7A.
Yeah.
That switches off the end user's obligation under 710.
Yep.
Which in turn switches off the employee's liability under Section 222.
Yeah.
So what that is doing is forgiving the employee of a liability.
No, it's not.
Because on day one,
The liability doesn't arise.
well,
The liability to tax in the first place has already arisen. That's nothing to do with 222.
no, my lady,
Liability under 222 only arises if there was an employer's obligation to deduct, the employee didn't, and the employee didn't, within 90 days, make good the due amount to the employer.
yes. So
That's when the charge arises. But
just
if there's
applying-
no obligation to deduct or account
just
on
applying,
the employer,
just applying it to the facts of this case.
yeah, sorry.
So we know that everybody thought Rangers worked, so tax wasn't accounted for. But in fact, we know that the correct analysis is as set out in Rangers. So there was, in fact, an obligation to account for tax under Section 710. This is before they have the revenue exercise any power. Undoubtedly, that it was more than 90 days before anything, tax hasn't been reimbursed now. So undoubtedly, we're past the 90-day limit. So if taking figures of 100, if the benefit was 100 and the obligation to account for tax was 40, at day 91, the employee is deemed to be in receipt of income of 40. So his income was previously 100, it's now 140. We then go sometime down the line, the CIP issue their guidance, HMRC exercise their discretion. At that point, they say, retrospectively, we remove the employee's obligation to account. But also retrospectively, we remove the end user's liability to account, but also retrospectively, we remove the employee's liability on the grossed up amount, i.e. of the 40. So the employee's liability after the discretion has gone down from 140 to 100. And so that's why I say what's happening is the employee is being relieved of a liability of 40. And that's a liability at the stage one.
Right.
And that, it seems to be, is precisely the thing which I was saying you certainly can't do, but my little friend was saying as well that you can't do by way of discretion. That's forgiving tax. And I appreciate that the people who are being forgiven the tax is the claimants. But that doesn't undermine the relevance of the point. If it was a third party coming into court going, well, the revenue shouldn't be forgiving anybody tax, then the issue would be the same. And my lady would then take me on briefly to the public law arguments. And I think probably the best I can do here is to clarify our position in terms of what we're saying. Firstly, the knowledge of the end users was a relevant factor.
Relevant or irrelevant?
Relevant. I think the argument that it was irrelevant clearly fell away whenever we saw the guidance, and the only factor which was in there was the knowledge of the end user.
Right.
And the reason why it was relevant is because it was identified by HMRC as a relevant factor in their guidance. And we complain that they didn't investigate that. And my little friend made the point that the degree of investigation is a matter for HMRC, subject only to a rationality challenge. We say that the approach taken was irrational.
Yeah.
We also say that addressing the question of whether the employer would have been aware of the obligation to operate PAYE, rather than the issue in the guidance, which was put as, would the employer become aware of their arrangements with due diligence? Applying that wrong test, that was unreasonable. So hopefully that puts our arguments on that a little bit clearer. And apologies. Then, in relation to legitimate expectation, we just say that in terms of what's in the manual, it's not addressed to the outside world because it's an internal manual. But it is a clear statement of what HMRC regard the law to be nonetheless. And a very rational statement of what they regarded the law to be, given that it reflected what the House of Lords had said, Lord Mackay, in the Heard case, which I took you to. And the point was put, well, what we were saying is that HMRC were precluded from ever using their very general power by reason of what's in the manual. That's absolutely not what we were saying.
Well, what's the legitimate expectation then? They say they'll use the directions.
Yes.
But they don't say, but we won't use any other weapon in our armoury.
Well, they say that
if must be, if you're to get some sort of legitimate expectation out of it, that is what is meant.
Yes, for so long as that's their stated guidance, but it doesn't mean that they can't use the general power in other ways for other factors, because the general power, after all, is a general power not to require a payer to comply with PAYE obligations. Now, there are any number of PAYE obligations which that could relate to.
So it is what you're saying that if the circumstances are such as could give rise to the exercise of, say, a Regulation 80 direction, then they can only use Regulation 80.
Well, that's what they were saying. We will only use Regulation 80, and that was the legitimate expectation. Yes, that is what I'm saying.
So
and
they are excluded.
To that extent,
yes,
they're excluded.
Right.
But they're not excluded more generally from using the power. And I think it appeared to be being suggested that it would render the power a dead letter, but clearly that's not the case. So in terms of the jurisdiction arguments,
yeah,
I've just taken you to Regulation 188. I don't think we need to go there again, but as I pointed out while we were there, the term tax payable under the assessment is a defined term meaning liability. And the whole point about that provision is that you're working towards the tax payable, which is also part of the assessment. As is made clear from Hallamshire. Now, there was an attempt to dismiss Hallamshire as dealing with a more extreme argument and actually dealing with self-assessment, and being before self-assessment. Now, in terms of self-assessment, I think that argument has been addressed and dealt with in the Archer case. Mm-hmm. But if I could just quickly take you to the judgment, because it's absolutely clear from that
in Archer or Hallamshire?
The judgment in Hallamshire, sorry, which is at tab 5 of the authorities.
Page?
Sorry, I'm just pulling it up now. So the decision starts on page 53, but if we could look at page 51, sorry, it doesn't start. Sorry, I was looking at the wrong page on the Adobe.
51, yeah.
Yeah. So if we just look at G there, he's going through the statutory scheme in the Taxes Management Act. But he then goes, there is a proviso providing for the adjustment to take account of the High Court's decision, and then the assessments and claims having been made and all the appeals determined, Part 6 of the Act deals with the recovery and collection of tax, starting with the demand for payment by the collector under Section 60. So he's referring to Section 60, which is a collection provision.
Yep.
And when we go to the bottom of page 52, at H, see, halfway through the paragraph, yet the Crown argues that it would fully have discharged its functions of assessing and giving notice of assessment without specifying any amount of tax payable, merely by stating the facts which would enable someone skilled in tax matters to compute the tax which the Crown is going to demand under Section 60, such demand probably not being made until after the time for appealing against the assessment has expired. In my judgment, the words for the words of the statute would have to be very clear to force the court to that conclusion. So he's referring to Section 60, the collection provision, which is the point I want to make there. Because I think the point is made elsewhere that, well, Section 59A and 59B, they're collection mechanisms and they've got nothing to do with assessment. Here, what we can see is that in terms of an assessment, as Brian Wilkinson's construing it, it very much does have something to do with what's required to be in the assessment. And then that also fits up with what he says at A on page 54. A man should be told what tax he has to pay. And that couldn't be more clear and straightforward. And as we looked at, 188.5 supports that analysis. We don't rely on it on its own, but we say it's entirely consistent because it's talking about the amount shown in the notice of assessment. In terms of Regulation 185 and jurisdiction in relation to closure notices, what I'd say in relation to the deeming is that we don't need to show any wider deeming than Section 59A or 59B. But insofar as that's relevant, what it says is that the deeming is stated to be for the purposes of those two sections. It doesn't say that it doesn't apply for any wider purpose. Nor is it necessary to read any such limitation in.
Well, why refer to those provisions then?
Well, to make it clear that they rely particularly for those provisions.
It doesn't say particularly for, it just says they apply for those provisions.
Well, oh, yes, sorry. Sorry, particularly is my gloss. But it's making it clear that it does apply for those provisions. So there's no question that it applies for those provisions when you get to those provisions. But there's a difference between saying it applies for those provisions and only those provisions, and it applies for those provisions, and may have wider consequences for other provisions. And in context of the approach to deeming, we say there's no reason not to let the deeming flow through. But the reason why we don't need to rely on the deeming is because of the words of Section 8, subsection 5, which just requires you to identify tax which has been treated as deducted. And tax treated as deducted for the purposes of Section 59A or 59B perfectly meets that description. And I think it is useful to note that there's a distinction in the approach taken in Regulation 185, which deals with self-assessments, from Regulation 188. In Regulation 185, the draftsman goes out of his way to define the credit as tax treated as deducted.
Yep.
You don't find those words in Regulation 188. It does the same thing, but it doesn't use those words. And what I'd submit is that that's deliberate, and the reason why you find it in relation to the self-assessment one is because those words are relevant to what needs to be contained in a self-assessment. It's harking back to what's said in Regulation 8.5, when you get to another type of assessment, tax treated as deducted doesn't come into it. And what it's about is there's a clear, reasonable route to a correct jurisdiction. The alternative, bearing in mind that we're looking at provisions about self-assessment, is that taxpayers have to complete tax returns which state that the tax payable is something different from what any normal person would understand the tax payable to mean. And that's obviously an absurdity, and the court should strive to avoid such an absurdity, if at all possible, in adopting a construction. And there's no need to adopt a construction in order to cut down the jurisdiction of the tax tribunals. This isn't the sort of Beadle situation where there are clear words of necessary implication that these sorts of cases shouldn't be before the tax tribunals. They have been in previous years without any problems, and there's no reason not to have them. And in fact, we'd submit every reason why this is exactly the sort of thing which the tax tribunal ought to be dealing with. Well, that completes my points in reply, unless there are any further questions.
Thank you. And that's probably a good moment, given that it's 1 o'clock. How long do you think you'll be dealing with the TOAA submissions? Just so that I can get an idea of whether we need to start early tomorrow.
In terms of the timetable,
Yeah.
I think we're exactly where we needed to be in terms of starting tomorrow.
So we can start at 10:30 without any...
We can start at 10:30, yes.
Good. All right. Well, thank you very much then. 10:30 tomorrow morning.
Yes.